Good morning and welcome to the Committee on Government Oversight. I call the meeting to order and we will have committee members introduce themselves. I'll begin on my left with Representative Fay.
Good morning, everyone. I'm Jessica Fay. I represent House District 66, which is parts of the towns of Casco, Poland, and Raymond.
Good morning, everyone. Someone Millet, House District 71, towns of Norway, Sweden, Waterford, and West Paris. I have to apologize. I'm going to have to leave earlier to the chairs for meetings at around 11:15, but.
Morning, everyone. I'm Mark Blyer. I represent District 22, which is part of Buxton, Standish, Limerick, and all of Leamington.
Good morning. My name is Amy Arata and I represent House District 65, which includes New Gloucester and part of Poland.
Good morning. My name is Holly Stover. I represent House District 89, which includes the communities of Boothbay, Boothbay Harbor, Southport, Edgecombe, Westport Island, and South Bristol.
Good morning, everyone. I'm Donna Bailey, proudly serving Senate District 31, which is Saco, Old Orchard Beach, Hollis, Leamington, and part of Buxton.
Good morning, I'm Senator Susan DeChambeau. Oh, I'm used
Rusty.
for it to come on automatically. Okay, teach me all over again. Yes, I'm Senator Susan DeChambeau. Next door to Saco is Biddeford, so I represent Biddeford, Dayton, Lyman, Alfred, Arundel, and Kennebunkport. Thank you.
Good morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is northern Oxford County and two communities in Androscoggin.
Good morning, everyone. I'm Senator Jeff Timberlake. I represent the towns in Androscoggin and Kennebec County.
Thank you. And I am Nate Libby. I proudly represent all of the people of Lewiston in the Maine Senate. And I serve as Senate co-chair of the committee. We are going to take up, I don't recall seeing meeting minutes in this packet.
We've had a technical difficulty with our meeting minutes.
Okay.
We will have them for next meeting.
Okay. Okay. So we will take those up at our next meeting. We'll move on then to continuing our work session on the OPEGA report on the research expense tax credit. We had public comment a couple meetings back and delayed taking action on that report. The staff have provided us a high-level summary of that report, the executive summary, and that is behind which tab? Tab 1. And so now it's really for discussion for the committee on what to do for next steps. As a reminder, at least in this 130th legislature, the GOCs tended to not opt to draft legislation for submission to a committee. We've tended to defer and give committees of jurisdiction that ability to introduce legislation based on our findings. In the past with credits like this, we've typically communicated via letter about the high level findings and recommending that policy committee take action. However, now that we've adjourned, it's sort of in an awkward spot where the taxation committee is not going to be able to take any action in the 130th. So one suggestion is we carry this forward to the 131st and have this committee transmit a letter to the next taxation committee and try to ensure that these findings get incorporated into some piece of legislation next year. So that could be a recommendation for how we move next. And so open up the floor for discussion. Sounds like that was a good idea from the chair. So is there a motion?
Yes.
Moved by Senator DeChambeau to transmit a letter to the 131st Taxation Committee.
I will second that.
Seconded by Representative Stover. Further discussion? All good? All in favor? Is opposed? It's unanimous. Sorry, Sabrina, I should have, you're good? Okay. All right, thank you, committee. The next item on our agenda, we've invited a guest here today to have some discussion with us about confidentiality matters, specifically with respect to documents surrounding the Office of Child and Family Services. So we've invited Chief Deputy Attorney General Chris Taub to join us this morning. Chairs and leads have had some discussion with the Chief Deputy around these issues. We thought it would be useful for the committee to hear some of these questions and answers. And so I welcome Chief Deputy AG Taub here this morning. And I can start by posing a question, or I can turn the floor over to you. What's your preference?
I think it might make sense to try to answer your questions.
Sounds good. So first question we had is, can you speak to what ability the GOC has to meet in executive session to discuss otherwise confidential matters or documents that are not presently available to us as public elected officials?
Yes, I can address that. And just to introduce myself again, I'm Chris Taub from the Attorney General's Office. Senator Libby, Representative Stover, members of the committee, thank you for having me in today. With respect to your question, so under the Freedom of Access Act, there is a provision that allows government entities, including legislative committees, to go into executive session for certain purposes. And I think the one that would most directly apply here is that, and I'll just read from the statute, and I think you might have some of this in your notebooks, but I'm looking at Title I, Section 405 of the Freedom of Access Act, which relates to executive sessions.
Sure, Senator DeChambeau.
Is there a place where we should be looking at?
Go ahead and answer.
I don't know when to take my notes.
It's under tab 2. Yellow page.
Goldenrod, some people would call
Okay,
it.
it's golden.
And I apologize, I don't have the notebook, so I can't direct you to the right place. But what I'm looking at is Section 405 of Title I, which is entitled Executive Sessions. And if you turn to the second page, paragraph F authorizes executive sessions for discussions of information contained in records made, maintained, or received by a body or agency when accessed by the general public to those records is prohibited by statute. So if the committee came into the possession of confidential documents, it could then go into executive session to consider those documents. Now that sort of begs the question of the extent to which the committee can obtain those documents in the first place. But assuming that the committee does have possession of these documents, it could review them in executive session. And there's some sort of logistical issues around that, which I'm happy to address, but maybe I could wait for the next question.
Sure, thank you. Questions or comments in reaction to what we just heard from the Deputy AG? I guess I would prompt you to answer the next question, which you're anticipating, which is the nature of how we get those documents.
So from meeting with the chairs and leads and just sort of my general understanding of the recent work of the committee, my understanding is that there's an interest on the part of the committee in directly reviewing certain child protective records that are confidential by statute. That is somewhat challenging because the committee stands in sort of a different position than OPEGA does. So the way that the statutes are structured, OPEGA is kind of designed to be sort of the investigating arm of the committee. And so the statutes that govern OPEGA directly address OPEGA's ability to obtain confidential documents. In fact, there's a specific provision that says that OPEGA may obtain, in fact, agencies must provide to OPEGA documents that otherwise would be confidential. And there's also sort of a very elaborate process that's set forth in the statute regarding how OPEGA gets access to those. It has to make certain findings as to why the documents are necessary. It has to agree to treat the documents the same way that the agency would. It has to make arrangements for what to do with the documents when its work is over. So the statutes really contemplate that OPEGA is going to be the entity that is going to get access to confidential documents. And that's not to say that the committee can't do it as well. It's just, it's a little bit more of a cumbersome process, and it's not certain that the documents that the committee would be interested in are going to be available to them. So I'm going to turn to another statute. And again, I wish I could direct you to the right place in the notebook for this. But it is Title 22, Section 4008, which is entitled Records, Confidentiality, Disclosure.
Just pause for a moment, if you would. Behind our blue tab, Title 22, Section 4008, is that correct?
That's correct.
Yes,
Right.
behind our-
And so this is the primary statute that governs the confidentiality of child protective records. And it's a fairly lengthy statute, but just to sort of give you a very brief sort of idea of the structure of it, it essentially broadly declares that almost all child protective records are confidential, but then has a series of provisions under which the department may optionally disclose documents to certain types of entities or individuals, and then also has a separate set of provisions for the conditions when the department must disclose the records. So in order for the committee to get the records, as opposed to OPEGA getting them, the committee would need to fit within one of the statutory exceptions under which an entity can get access to records that are otherwise confidential by statute. And I think the one provision that I think arguably would apply here is if you turn to page, I think it's probably should be page 3 in your copy. And it should, at the top of the page, it should have paragraph A1, and then it has A1, B, C, and D at the top.
Yes.
So paragraph D, and so this is within the provisions that are the mandatory disclosure. So these are the provisions that require DHS to provide the records. And so what D says is an appropriate state executive or legislative official with responsibility for child protection services, provided that no personally identifying information may be made available unless necessary to that official's functions. Now, this is a provision that I'm not aware it's ever been interpreted. There's not really anything out there that sheds much light on sort of what the intent of this provision is, because I think, you know, an appropriate state executive official with responsibility for child protection services, that's sort of an obvious category. It's really not clear to me sort of what type of legislative official with responsibility for child protection services, sort of what type of person that would be. But I think that there is an argument that can be made that the GOC is sort of a body of legislative officials that have responsibility for child protection services, because among their many sort of, you know, duties or responsibilities is the oversight of state agencies, and including the Child Protective Services Agency. So I think that there's an argument that this paragraph would authorize the department to provide the records that are otherwise confidential to the committee. That's not to say that, and just to kind of clarify, you know, I mean, our office does represent DHS, obviously, but my role is to sort of represent this committee. So I have not talked directly with DHS. I don't know if they share my view that this arguably applies. That would be up to them to take their own look at and to consult with the AAGs in our office who do advise the department on a routine basis. But certainly one option for the committee would be to make a request to the department, citing this provision, explaining the context of it, explaining that, you know, that you view yourselves as a legislative body that has responsibility for the oversight of child protection services, and then make the request for whatever documents the committee is interested in reviewing. Now, let me just pause there because there are some logistical issues that I want to talk about, but I've given you a lot of information. And so I want to pause and see if folks have any questions.
Senator DeChambeau.
What comes to mind is that particular one is that PL, it's 2001. So we don't know of any case law or any other states, especially with confidentiality. I'm sure someone has challenged that, but
Yeah, so a lot of the statute, there's a whole federal overlay that's going on here because there are a series of federal laws that require states to have certain provisions when it comes to child protective documents. And so a lot of the language in this statute is sort of lifted from some analogous federal language. And so it might be that in other states, there's sort of a more defined universe of legislative officials who are charged with child protective matters. I mean, it might be that this is a provision that really doesn't match very well in Maine, might match better in other states. But the short answer to your question, Senator, is that this has just never been litigated before. There's no opinions from our office. There are no court decisions that I'm aware of. So that specific provision just has not been looked at before.
so to follow up what I'm hearing you say is if there's a child from Maine that had a case or there was a case on that child and there are some documents and the family moves to Florida, would Florida be able to access the Maine documents?
So I
And
believe,
vice versa.
yeah, so there's a whole other set of provisions in here that either authorize or require disclosure. And I'm not an expert in this area, but I'm fairly confident that there are provisions in here that when a child moves from Maine to Florida, and now the Florida Child Protective Agency wants to get access to the documents, I'm fairly confident that there are provisions in here that would allow or maybe even require DHS to transfer those records to Florida.
Thank you.
Senator Timberlake.
Thank you. I'm sorry that I got to skip out because I think this is very interesting and very important. But I'm going to go out and join a rally that's outside here for our Pipe Rest kids with the foster parents. So I'll be right back as soon as it's over. Thank you all.
Thank you. Thank you for grabbing the mic. So further questions or comments on this subject?
I have one question.
Representative Stover.
And this may not, thank you, Chris. When it says legislative official, and I can't find in here anywhere, well, that's any further defined.
It's not.
So it could be committee of jurisdiction, which is the HHS committee, or it could be this committee doing its investigatory work. The barn door is pretty wide.
It's wide, or it might be narrow too. It's really not clear what this is supposed to refer to. I think you can make an argument that it refers to the GOC. You can make an argument that it refers to the Health and Human Services Committee, or it might not refer to anyone in Maine. It's just an open issue.
Or state executive. State executive.
The state executive, I mean, a state executive official, there certainly are state executive officials who are charged with child protection. For example,
Right.
I think the ombudsman would fit in. I think, officials who work directly for the department would fit into that.
And and others like yourself.
Yes. Yeah.
Yes.
Potentially. Yeah.
Yes, thank you.
So thank you. So can you talk about some of the logistics with how, say we take a step where we transmit a request for some documents, and let's set aside for a moment what those documents may be. Can you talk a bit about how logistically we may view those documents?
Yes, and so this gets into the part that I think is going to be a little bit cumbersome for the committee potentially. I think that the committee is going to have to review the documents in executive session. So this isn't a situation where the committee members could, review the documents on their own time at home or in their offices, or, sort of whenever their schedule permits. I think what would have to happen is the committee would have to convene in executive session. The records would be presented to the committee at the session. The committee members would review and discuss the records. And then once the executive session's over, the committee would either have to destroy or return the records. And I think in terms of just very logistical sort of details, there are probably different ways to do this, but the way that I envision it probably being the most practical, or maybe not practical is the right word, because this isn't terribly practical, but I think sort of the best option would be that, assuming that the department agrees to provide the records to the committee, I think what would make sense is for the department official to actually come to the executive session with the records, present the records to the committee, and then the committee would take as long as it needed to review the records. And then at the end of that process, the committee would return the records to the department official. And then, if one day wasn't enough and the committee wanted to do a second day, then you would just do the whole thing all over again. Now, I recognize that's a cumbersome process, especially depending on what the volume of records ultimately is. But I think logistically that probably is the way that you'd have to do it.
In terms of the records we might be interested in reviewing, I know Senator Khan.
Thank you. Yeah, before we go on to that I think I just want to kind of flesh out this just a little bit more, only because, if it's a easily digested document, that would be fine. But if we're actually going to do our oversight work and if we're going to be trusted with these documents, realistically, we could be in a room and take pictures of them. If we wanted to transmit the documents in some way or make them public, no matter where you stick us in a room with the documents, we can do that. So I think in a way we need to be trusted if we're going to be trusted to do this. But if I'm going to get several pages of information in order to do, to really dive in and think about it and think about the questions I might have around that, I'm going to need some time with that information. So to think that all of us are going to be able to have the same amount of time at the same moment, I understand, wanting to put parameters around it. I just think we need to make sure they're practical parameters, and none of what you said is specifically outlined here. So is that personal opinion? Are you, just coming up with something that you believe makes other people feel more comfortable versus, where are we legally bound here? Because in order to do the job well, we need to make sure we can do the job well.
Right.
So I just wanted to kind of talk that through a little bit more, and maybe, it's some one pagers and they're quickly digested, but if it's more in depth, I think it's not so easy to get all of us to have, 8 hours where we can all sit in a room together and read something. It's just not practical, and no one else that does oversight is expected to do it in that manner. So that's my question. And it does say here that personally identifying information is removed. So I don't know the extent of that either. So just wanting to hear your kind of feedback on that.
Those are good questions, Senator. So I think I think what you're asking is it really necessary for the committee to review the records in executive session, or is there some more sort of feasible, practical way for the committee to look at these? And I think there's sort of two different answers to that. First is that under the joint rules of the legislature, this is Rule 313. It says that the committee shall protect confidential records, including those records excluded from the definition of public records. So I think under the legislature's joint rules, you would be required to go into executive session to review the documents. And then I think the other issue, and this is sort of not as much a legal issue as a practical issue, but ultimately it's going to be up to the department to decide whether they're going to provide you with these records. And I think that if the department was very confident that the confidentiality of the records is going to be strictly maintained, they'd be more comfortable providing you with access to the documents. If they were concerned that you were, for example, going to take pictures of the documents, or that you were going to take notes and then the notes somehow get disclosed, I think that the department probably would then be, more reluctant to provide access to the documents. So I think those are the two reasons that I have for believing that you really would need to go into executive session to review the documents. And to your point, Senator, I recognize this is not a process that makes a lot of sense. But I think this really goes back to the fact that the way that the statutes are structured, it was really contemplated that it would be OPEGA that would be doing the heavy lifting, that they would be the ones that would be pouring through the documents and analyzing them and then synthesizing that in a way that's helpful to the committee. And so I think that that's really the source of your frustration is that the way the process is set up, it wasn't really designed to have the committee sort of doing the really deep look into the documents.
Okay, thank you.
Representative Stover, followed by Senator DeChambeau. Senator DeChambeau.
Thank you. Just to follow up, and that is a good question in that I had the question, but my thinking wasn't as involved as Senator Kimes. I think this is a good discussion because we have to decide what kind of documents, what kind of information we want. I did not envision that we would have access to it to the point that we could take pictures of it and transmit it and have our own time. It's a valid point, but I just don't see, having been this few of us that have worked for state government, that kind of documentation is that available. I like the other thing, I don't think we would be able to decipher what's in those documents. There's terminology we wouldn't understand unless someone explained that to us. So I think, having said that, I just thought there would be a synopsis of it, maybe through, and that's a good point, if it was OPEGA staff doing that. But I think we need to decide. I don't have a clear idea of what kind of documents I would need or information. Just that the last meetings we've had, people think we're delving in too much and that DHS is not providing them. I want to wipe that clean. And that's what we've been discussing is the confidentiality, the records, but I can understand if there's some guardrails to that. So I agree that OPEGA should go through that, but we have to tell OPEGA what it is we're looking for. We'll probably need someone from DHS to the whole terminology and what that really means. So I think that's some discussion we should have, but I thank you. So I agree. I just don't think it's going to be that broad. We're just taking a peek, but we want to get something out of it too. Thank you.
Can you speak to the statute that governs conduct in executive session and after executive session? I mean, we've heard suggestion of photographing documents, but it's been a long time since I've been a local official going into executive session. There are penalties associated with violating those terms, I believe.
That's a good question. I'm actually not, I don't want to talk off the cuff on this one because I haven't looked at it ahead of time. There certainly are penalties for violating the Freedom of Access Act. And then the other thing that the department or that the committee should be concerned about is that there are penalties for violating the DHS confidentiality statute. So Title 22, 4008. In fact, I think I think it may be a crime to.
Is that on page 4, Chris?
Let's see.
Under unlawful dissemination?
Yes. Yeah.
Thank you.
Yeah, thank you. That is what I was thinking about. So there are some penalties associated with the improper disclosure of child protective records.
Senator Bailey, followed by Representative Millet.
Thank you, Mr. Chair. So AAG Todd, I'm just wondering if you're aware, there are certainly other panels, agencies that routinely look at confidential information. The child death and serious injury panel comes to mind, but I'm sure there are others. And so kind of the process you are setting forth, how does that compare to other panels and agencies that routinely receive confidential information and how they handle it?
So I don't know that I can give a great answer to that question, Senator, but I think what I suspect is that there are specific statutes that authorize those kinds of panels and agencies to get access to the documents. So for example, the Child Death Review Panel, I suspect that there's a statute that expressly authorizes them to receive those documents. And that's sort of the challenge here, is that when it comes to the GOC, there isn't a specific statute that authorizes you to access confidential documents.
So I understand that. So assuming again, what you've outlined does authorize us, I'm more interested in, again, the actual process. How
yeah.
do they do that?
Yeah.
Because it might give us some ideas of how to handle things. And if you're not aware, that's fine.
I'm sorry, I misunderstood your question, and that's an excellent question. I don't know the answer to that.
Representative Millet.
Thank you, Mr. Chair. I'm wondering if you could create a scenario for us that addresses the issues that we're kind of probing with you in terms of the legal steps and the authority that we as a committee, that I think clearly would fall under the phrase of legislative official with responsibility for child protective services. If you were able to describe in legal terms with proper references to statutes, if this committee were chose to look at personal records of, let's say, multiple children deaths within the scope of our reviews over the past few years, could you define the first step, meaning would GOC as a committee be authorized to a vote to empower one or more persons on its behalf to make this request? And if that request were handled in a way that was not personally identifying an individual case, and the chain of command of that information being mandatorily provided were either done securely within the staff and their authority, and then brought to the committee, not for distribution in advance or for personal copies to be taken home at our leisure, but made available at a properly called meeting of the committee, wherein a public vote to go into executive session could be held with council present, with staff, with all of the protections that would apply to it. I think that would be helpful if you were able to, with your legal background and the material you provided us this morning, just kind of sequence that in steps. If the committee were interested in pursuing information relevant to some tragic occurrences within our purview, and we were to vote to authorize a person or persons within the committee or on behalf of the committee to make that access, how it would be protected in the chain of command to a public meeting when a executive session could then be held, and making sure that none of the personally identified information ever found its way into the public arena. Is that something you could do in kind of an outline form, just to give us something to chew on?
Yeah, so I'm not sure if this totally answers your question, Representative, but I've already had some discussions with Matt and Scott and some of the other folks at OPEGA. And I think in terms of sort of the process, what I envision would be, if the committee wanted to pursue this, would be a letter from the chairs or from some members of the committee to the department, specifying the precise records that they want to review and sort of explaining how the committee is going to treat the records. And I'm more than happy to work with the folks at OPEGA and sort of crafting that letter and, making sure the right legal language is used and the right statutes are cited and all that. I think, in terms of what happens next, I don't want to overstep my bounds and tell you folks how to do your job, but I really, I guess, would urge you to consider using OPEGA then to review the records, because they have the authority. In fact, you wouldn't even need to do a letter, because OPEGA can just directly request records. So if you charged OPEGA with something specific and said, this is what we want you to look into, these are the records that we want you to get, I believe, and certainly Scott and Matt can correct me if I'm wrong, but I believe that then they could directly request those records. I think the department would turn them over, and then at a session, and I'm not sure it would even have to be an executive session, But I think OPEGA could sort of synthesize their findings from those records in a way that really doesn't disclose the specific information in the records, but would synthesize it in a way that would be helpful to the members of the committee. And I don't know if I explained that very well, but I really think to the extent that you can use OPEGA to actually be the ones who are looking through the records and synthesizing it for the committee, that is going to be an easier process. If you don't use OPEGA, then I don't see an easy way forward other than that process I said at the beginning, which is for the committee to go into executive session to review the documents, which again, as Senator Kimes pointed out, is going to be a cumbersome process. Did I answer any part of your question, Representative?
You did a great job. And I think the value that I'm taking is the way in which you frame the staff in their broader authority to access the documents, synthesize them, and sanitize them from any personal identifying material, and then make them available to the committee. Because I was nervous when I framed my question of 12 of us sitting around here with a document in front of us, trying to read it intelligently and carefully. I would much prefer and feel better if it were done within the scope of the OPEGA staff review process. So it sounds like you've been thinking this through, and I think you've given us some pretty good guidance.
Yeah, I mean, again, I don't want to tell you folks how to do your job, but I have been thinking about this a lot, and I think what's going to be more helpful to the committee is not reviewing, specific case files or sort of specific incidents, but having OPEGA to do sort of more a comprehensive review, so they can come back to you and say that, we looked at 20 cases and we found that in 8 of the cases, DHS had interactions within the last 4 weeks before the child's death, or, and I'm just obviously making up hypotheticals, or, in 4 of the cases, we found that law enforcement was involved or whatever. Like that seems to me that would be more helpful to the committee than the committee actually sitting down with this pile of records in executive session and trying to make sense out of them.
Representative Stover?
I'm just trying to pull this back together, both for the committee's sake and mine. And the Government Oversight Committee, all of us here serve because we share a conviction that government can do better. And we look for the opportunities, and we serve on this committee to ensure accountability of state government. And what we know, and the work that we've done to date, is that what we know in 2021, we saw 4 cases that were homicides or where parents have either been charged with murder or manslaughter. And I think we're talking about a total, if we said a pool of 4 cases, if that were what the committee decided to do. But I think the facts that we've also discovered in our discussions as a committee is that none of the children that died last year in May and June were in state custody, and that 2 of the 4 fatalities may have had findings of abuse and neglect. So I think about what we want to see in terms of records, and what the committee's desire really is to look at levels of transparency, and look at what exists in a record. And I believe that DHHS has voluntarily provided a lot of data, which is where we get the number of 4 children in the homicides. There's a number of 29 deaths going around, but I want to be honest, in my looking at that and the data that DHHS has provided, some of those are car accidents. And God forbid any one of us face that in our lifetime, or SIDS. And I've had a family member lost their baby to SIDS, and that is not a child welfare death. That is a very tragic death that you never get over. And so I think we need to continue to pursue our work, but I think we need to be sensitive so we don't need to know all the stuff, because as we have discussed in this committee before, and this may be my perceptual bias, is that some of this material needs to be left aside for trial prep and for the courts to decide. And what we need to know really is about the involvement. And I think we can do that in ways that you've described today. And I want to just appreciate all the work that you've put into this, and also thank you.
Thank you.
Further questions? Representative Arata?
Is now a good time to move on to the structured decision-making tool questions?
Certainly.
So that's something that's come up, and that's a proprietary product that's sold, I guess. And so what ability do we have to examine that tool?
This is a new one for me. I don't know anything about this tool or sort of what the proprietary confidentiality provisions would be. But, you know, I would suspect that if you made a request for it and, you know, you agreed to keep it confidential, you know, it's gonna be up to the department, but I think that there's a decent chance the department would agree to provide it to you.
I mean, my understanding is that it's intellectual property, and so therefore we can't copy it, sell it, compete with that company. It's a tool that's provided to all the case workers. And so it seems to me it would be very easy for us to be able to examine that and kind of see how the decisions were made, you know, with placements that didn't go so well.
So I think, because again, I don't know anything about this document, but I guess what my suggestion would be, which is that if you do want to get a copy of this, you would make a formal request to the department for it. And then when we get the response back, I'm happy to review the response. So for example, if they say, you know, yes, you can have it, obviously there's no issue. If they say, you know, no, you can't have it for the following reasons, you know, I'm happy to do sort of a review of that to sort of give some advice to the committee about whether or not, you know, they have a legitimate concern or whether there's some other argument that could be made. But I think the first step is we would need to get something, a formal request to them and then a response so we can understand exactly, like, if there is a concern about disclosure, exactly what that concern is.
I believe it's a computer program. I don't know if it's a document specifically. I think it's a tool that comes in a computer program, assessment tool. So I don't see why we couldn't walk through it and, you know, let's look at Amy's custody of her dog. You know,
Yeah.
is she a good parent of her dog? You know what I mean?
Yeah,
We could go through the scenario and try and, so we understand it.
I mean, and again, I'm just making stuff up at this point, but I mean, I don't know if DHS would be willing, you could ask them to do a demonstration. You know, you could have them come in with a computer and a PowerPoint and say, like, how would a caseworker go about, you know, entering information when they get this prompt, like, what do they enter? Again, I have no idea if this makes sense or not, but just
But that
something
would
that
need
comes
to be an executive session because we can't put those questions out there to the public.
Well, I mean, if they were running through sort of a hypothetical case, and if we can resolve the issue about whether this really is proprietary or not. I mean, again, I don't know a lot about intellectual property, but, you know, I'm sure that the code itself is proprietary, but I just don't know whether that would also apply to someone just doing a demo of the software. And again, I probably should stop talking because I really don't know what I'm talking about. But I feel like if we could get a better idea of sort of what you're interested in, I think there might be some kind of path forward.
Okay, thank you.
Senator DeChambeau.
I've been hearing about tools both in criminal justice and public safety in prisons and Department of Human Services. And I had been in the business a long time and had to learn about the tool. That's something I don't think we've ever been very clear on, especially with the Department of Health and Human Services proprietary. The tools, first of all, I don't believe are developed within Department of Health and Human Services. These are validated tools that are nationwide. It belongs to someone. That's been my experience in my department. And you purchase those. And you purchase, in other words, there's an agreement to use this tool and it belongs, the first ones we worked with came out of Canada. And then it came from a university. So the university was making money because research goes into that. Each time you used a tool, even the ones on the computer, there was a cost attached to it. And yes, you don't let, what's confidential is you don't let the person you're interviewing and assessing know the questions ahead of time because they can fudge the answers basically. And that's all been my experience in working with that. In part two, I don't know of any tool that doesn't allow for an override. You can ask the questions, you answer the questions, it says something that helps you, but you might override it for some reason based on other information. So you've got to have a policy attached to those tools. Now, there are people here from DHS. This is Sue DeChambeau talking about DOC. And I'd like to know where that tool comes from. That would tell you in terms of confidentiality, who really owns that tool? Or did the department create it? I doubt very much. And if it belongs to someone else, probably DHS's hands are tied. The other thing, and I agree with you, doing a demo would have to be an executive session, because again, you just don't let people know what you're asking. It's like going to get a polygraph and saying, what's he gonna ask me? You know, you don't know. And that's the value in the tool. So I hope I made myself understood on that one, but I think we've got to be that basic. Where's that tool come from? And they should be able to tell us it's University of Notre Dame or something, and then maybe take a look at it. But there's a lot of work that goes into that assessment.
Further questions or comments? I believe we have asked for details about the tool. I believe the department has provided detail. I've got several pages here. I'm not going to be able to flip to it immediately. If another committee member, Representative Barada.
I remember that they gave us a sheet that cites research related to the tool and how it's been validated multiple times. Research nationwide.
Do you recall
So-
where in the packet it is?
No, it was in a past packet.
Okay.
And I'm not necessarily questioning the validity or usefulness of the tool. I feel like we don't understand enough about the process. At least I don't. And so here we are trying to investigate this and help solve issues, and we don't know what we don't know. And that's the frustrating thing. Thanks.
So going back to documents that may be requested, we've had some discussion about what that could look like. And I think one thought was, well, what if we ask for the case file of a child who's been murdered, who had interaction with OCFS? And so can you speak to the challenges involved in us procuring that case file and trying to review it in a room together?
I mean, my experience with some of these case files is they can be very lengthy. It takes a while. The way that they're structured, it just takes a while to get like oriented to the file and sort of understand what you're looking at, how to make sense of the information. And I think it's going to be very, very cumbersome for the committee, especially if this has to be done in executive session where you have sort of a set amount of time. I think that's going to be very challenging.
Okay. How about something that's more of a summary document? We've heard that from members here this morning, and I think one idea was the department's internal investigation document when a child was murdered, procuring that document, which may provide sort of a summary of what went on internally. It's not tied to the criminal case, which is about prosecuting the person who's allegedly responsible. What we're thinking is that internal view, which is really what I think is of interest to this committee.
So, yeah, so I have talked with OPEGA a little bit, and their understanding is that the department produces something called the Child Death Serious Injury Internal Case Review, which it sounds like it has some kind of sort of summary of, for example, prior DHS history, coordination with law enforcement. So I don't know exactly how lengthy these things are, and I don't know if they're still being done or not. But if there are summary documents like that, that would be a much better thing to ask for than the whole case file.
Okay. Are you aware of any other types of documents that fall in this realm that I've described?
I'm not, only because I don't do child protective work, but certainly I think it'd be fair for you to ask the folks from the department sort of what kinds of summary documents they prepare in different kinds of cases. And then I think that would give you a better sense of what to ask for.
Can you tell us one more time the name of the document you referenced?
Yeah, and so this is, it's called the Child Death / Serious Injury Internal Case Review Tool, the CDSI. And I think OPEGA has gotten these in the past, but it's just a question of, whether DHS is still doing these, and also, you might want to ask a little bit about what sort of information might be contained in that.
Sure. Okay. Senator Khan.
So I feel like I have to clarify my whole point about taking photos, only because I think I raised a lot of eyebrows. Everyone thinks, oh my gosh, Senator Kime's going to take photos. I'm not, and I was never intending to. I just was trying to, when we talk about confidentiality, there's always some element of trust that comes in with it. Like, you have to expect that people are going to keep confidential what they're charged with doing, because there's always a workaround with the system. So I just like to be transparent about the ideas that there's always a workaround. And so at some level, it always becomes trust. So that was really my point, and the idea that if these documents are very cumbersome. One thing that Representative Arata had pointed out to us recently was the memorandum that Commissioner Lambrou gave us about Marissa Kennedy. And actually, probably OPEGA staff is better to answer this because they probably know, but I was wondering if that is in fact a child death or serious injury review file. Maybe that's.
Maybe a question for the.
Yeah, maybe we could ask the staff that, just because if that's what we're considering asking for the other children's files that haven't yet, this one's public because it's already been through the legal process. But if there are some that have not yet gone through legal process, or maybe they never will, I don't know. Maybe that's what we're looking at. So we could have an idea as a committee what it is we might want to ask for.
Thank you, Senator Kime. For the record, I don't think anyone expected you were talking about photographing the records. My eyebrow did rise, and I just wanted to make sure the public knew that there were penalties associated with that. But we all understood. Further questions or comments for Deputy Attorney General Taub? Before we let you off the hook, yes, Representative Arata.
As I was looking at the file or the information about Marissa Kennedy, I noted that she'd been to the emergency room multiple times, but there was never a report of the broken bones or any of the other things that they found after her death. What do we have any authority with regard to medical records?
I think to the extent that they're child protective records, it would be sort of the same authority that I think you would have, which is this idea that as a legislative body charged with overseeing child protective.
Well, it was interesting that there was no note about that type of injury in the child protective record. So that's the type of thing where a doctor would have to tell the caseworker, and it doesn't look like that happened.
Yeah, and I guess I should be careful too, because there could be separate confidentiality provisions that apply to medical records that even go sort of beyond the child protective. I mean, we've got the overlay of federal HIPAA and there's state confidentiality laws. So when it comes to the medical records, that might be a little bit different. But again, I mean, I think the first step, whenever there's a document that you, or category of documents, I think the first step is to make a formal request, and then we sort of evaluate the response. It's just hard to talk in the abstract, I guess,
Sure.
is what I'm trying to say.
Okay, thank you.
So I've heard a couple of suggestions this morning. One is considering that GOC make a request to the department to have a presentation of the SDM, Structured Decision-Making Tool. And a second suggestion of requesting child death serious injury internal case review documents for those cases that GOC has been interested in for 4 years now total. I have not heard that we want to request entire case files because of the cumbersome nature of that. And then I've heard a question about medical records. So I guess I'm looking for the committee to give us some direction about, do we want to make a decision on what we want to request today? Do we want to mull on it some more? Do we want to hear from the department before making that decision? What's the pleasure of the committee? Representative Rada.
As we're looking at the information about the child deaths, I would like to go beyond just those that have been deemed homicide, because there were some accidental deaths, especially with co-sleeping, where there was a history of substance abuse. And it would be interesting to me to see how did they make the decision to no, when they knew that there was substance abuse going on, how did they make the decision to let the infant stay with the parents? And as far as medical records, I think, you know, the report brought up the fact that it can be difficult to have communication between the medical profession and, you know, Office of Child and Family Services. So maybe that's something we can dive into with future reports, but I don't know if that's something that we need our Assistant AG to work on.
Okay, thank you. Further comments? Representative Fay?
Thank you. And I'm trying to figure out how to frame this. So we've heard a lot about the case files and how cumbersome they are. And I'll be honest, I've never seen a case file. I don't know what is necessarily in it, how cumbersome it is. And so I wonder two things. One, I wonder if there's a way without any information for us to have a sense of how cumbersome that case file is. What does it actually look like? I mean, honestly, that would be helpful for me for understanding what caseworkers deal with when they're actually dealing with these files, because it occurred to me that if it's cumbersome and challenging for the people on this committee to go through that case file, then it's probably cumbersome and challenging for other folks to go through those case files. So that's just, I'm just kind of putting that out there as an idea that's running through my head. If there's a sample, a blank, an example of the types of information or documents that are in those files without actually having them be filled out. Is that a possibility?
I think that's probably a question for not the Deputy AG, but for the department that could fall. Senator Bailey, followed by Senator DeChambeau.
Thank you, Mr. Chair. So I would just share with Representative Fay and the committee, I have seen case files. I've seen hundreds of them. And I will tell you that they vary. I mean, it can be this thick, it can be this thick, it can be 5 cases full. As far as being cumbersome though, nowadays they are electronic. So you don't necessarily have to have the thick folder. There is a lot of information that is repeated numerous times. So it takes a while to read through it and cull through what's important and what's not. So I think that's kind of a preliminary decision that the committee sounds like we're kind of talking about, which is, you know, first of all, do we want the whole case file? Do we want it first to be screened by OPEGA or others? I can tell you one thing that occurred to me in our discussion here that we do in the courts. And again, that's the world I live in. So when we need to get confidential records, for example, oftentimes in a family law case, we want to see the DHHS file having to do with this child. And in order to do that, we get what's called a Clifford order. And so we, again, you know, I want to see those confidential records. The court has the department bring the confidential records to the courthouse, and a judge actually goes through and reads them to determine, are they relevant? And then secondly, what if any information will be redacted before I can then actually view those records? Kind of sounds like that's what we're thinking about maybe having OPEGA do. That's what I heard Representative Millet kind of say. Can we have like OPEGA staff do kind of that initial review? And then determine, do we actually need to see that file, or is their review sufficient? So those are just ideas that I throw out there for information for the committee as we kind of go forward. I would like to defer making a decision till we hear more from the department, only because I'm thinking maybe some of these questions they'll agree to do voluntarily, and we don't even need to go through those steps, and we can kind of narrow down what it is we might need to do in a more formal basis. But I'm certainly willing to defer to the committee, but that's my thought, is to not make decisions right now.
Senator DeChambeau?
Thank you, Senator Bailey. for the information.
Mike, please.
Thank you. Mine is a follow-up of what Representative Fay was explaining, because I had the same thoughts also. And mine is very basic. Every time I thought of, why do they do this? What are they doing? What I don't want to hear is, forgive me, an administrator telling us, because the administrator doesn't work with that tool as much as maybe the manager or new hires. I'd like to hear probably from whoever instructs new hires, new caseworkers, what is it that they tell them about the tool? How do they instruct them? Welcome to the world of Child Protective Services. You'll leave after 5 years is probably the first sentence they say. At that's very basic, and that's where we are. It's very basic, as if we're being hired to do a job. What is important for the department? What are those tools? And what will they tell us? After I spoke the last time, I thought of, before there were tools, everything was subjective, right? Everything. Some of you don't remember that far back, but everything, if you met, and in my case, a new prisoner, it's how I looked at him or her. There was nothing to justify what my conclusion was. Tools are objective. It's a yes, no, maybe, cross, do the box. And you can rely on that. You're basing people on the same question. You probably hear a lot about overrides. That happens. So anyways, I just wanted to throw that out. I'd like to be taught by someone who teaches new hires. It's very basic, because sometimes we hear administrators or department heads, and I feel it's very detached. I'm just getting bureaucratic statements and no investment in that. And that's what I want to hear. Thank you.
Thank you. Further questions or comments? Okay. Deputy AG, thank you for your time this morning.
Yeah, thank you.
I did err this morning by forgetting to introduce our very capable staff who work with us at Opega, so I will try to do that now. First, we've got Senior Analyst Scott Farwell and Senior Analyst Matt Crook, who are sharing interim director responsibilities until the new director is appointed. We have Amy Gagne and Carrie Hojara, who are also analysts at Opega, and Sabrina Carey is our administrative assistant and committee clerk. And we thank them for being here today and for their work on behalf of the committee. So our next item for discussion is continuation of the work session on Opega's report, the final report dated March 2022 on Child Protective Services. We've submitted a list of questions to the department. These questions were generated by all of the committee members and were sort of pulled together by the chairs and leads, and then the staff helped consolidate it into a document for the department to respond to. Those answers are contained behind tab 2, behind the pink sheet. So the department did provide us those responses last night. What I'd like to do is have the committee walk through the questions that were asked, have the department explain their responses, fill in details where maybe answers weren't fully given. We can pause after each section to see if there are follow-up questions from the committee. Does that sound like an okay process? Okay. So with that, we'd invite the department up to the mic, and we'll have, unless you have other comments.
I'd just like to add that right behind their answers, in their answers, they reference a couple documents, a number of documents. We have provided their response to our report and a memo from April that they reference in their questions. So they're right behind the questions in your notebook.
They reference the April memo. And there's also a March memo, just for committee members to be aware. March memo is after the April memo. Okay, with that, we'd welcome the department. And if you would, please introduce yourself once you get up to the mic.
Good morning. Thank you. I'm Molly Bogart. I'm Director of Government Relations for the department.
I'm Bobby Johnson. I'm the Associate Director of Child Welfare Services within the Office of Child and Family Services.
Welcome. And thank you for being with us. So our first question for you is, what's OCFS done as of late? And we know we've asked this question several times. We're asking it because it's an important ongoing issue that we feel the department needs to address. What is the department doing to better engage and partner with law enforcement, healthcare providers, schools, childcare providers, and other mandated reporters? I want to give you the opportunity to maybe expand a bit on what you've written as a response.
Sure, I might ask Bobby to cover some of the highlights.
Thank you. So our staff and leadership partner with these stakeholders every day at both the local levels and at the systems level. We have work groups that we're involved with that those stakeholders are part of. They're part of our citizen review panels. I convene a work group monthly with law enforcement representatives from the medical field, as well as the Assistant Attorney General's office, where we're looking at some of the issues that were raised related to information sharing and collaborating on child abuse and neglect investigations.
I think one of the
I'm sorry, Molly, just one second, just as if I could follow up. Can you, Deputy Director Johnson, name the organizations who are represented at your work group that you just referenced?
Sure, we have the Maine State Police, We have Northern Light Healthcare, Eastern Maine Medical Center. We have the Maine Hospital Association, OCFS, and the Assistant Attorney General's office.
Okay, thank you. Ms. Bogart, go ahead.
Sure. I also just wanted to note that in the last month, we've rolled out a new tool for mandated reporters to use to allow them to submit those reports online. So this is for folks who submit multiple reports, know the process well, and is in part thanks to legislation that the legislature approved and the department proposed in the last session to allow some of this reporting to happen online. Previously, the statute allowed it to happen by fax, and we appreciate your help in updating that and also allowing for that tool to create greater ease and accessibility for reporters to provide that information to the department.
Okay. How is the department informing the public of the existence of this new tool?
Sure. I know from the public's perspective, it was there was a press release and information provided, but I'm sure that there was additional information to stakeholders.
Yes, we sent out information. So this applies to individuals that work within school systems, medical and hospitals, and then law enforcement. And so we disseminate information to those stakeholders throughout our state.
Okay. And is it still sort of practice where a mandated reporter makes a report but there's no confirmation sent back to the reporter, or there's no follow-up, right? From the department's
Through the
perspective?
mandated reporter portal, if a report is made, they get a confirmation that their report's been received. And oftentimes where we're in the early stages of rolling this out, our staff will do a follow-up phone call to review the information, get additional information if there is any. And so the reporters are getting that. They still always have the option of doing a call to our child protective hotline, as all mandated reporters are able to do.
Okay. One of the anecdotes we've heard is mandated reporters make a report and it appears to go into a black hole where they don't know if anything's been done or if it's even been received by a person. And so you said often a call is made, but
So they get a response that their report has been received, like an automated response.
sure.
And then at this point, we're often calling them back to clarify information and see if there's additional information.
Okay.
And I know we've discussed this with the committee before, but oftentimes we don't have an ability to share information about follow-up or findings from a report, and that we recognize that a number of mandated reporters want to know what has happened, what involvement has the department had with that family, what were the decisions that were made, but that's not information that we can share, and
Right.
recognize that creates frustration, but
Right.
it's not something we're often at liberty to provide.
Okay. Okay. Can you expand upon your answer? There really wasn't much here in the response on childcare providers and how the OCFS engages with childcare providers. I understand licensing is overseen by OCFS. I think we all knew that before, but can you expand on what that looks like beyond just the fact that licensing occurs?
Yeah, so we have childcare licensing, we have childcare subsidy program within the Office of Child and Family Services. So that is one pathway through which we receive information back from those stakeholders. We also have direct contact with them when they are providing services for the children that are in care. And so we're, helping to coordinate those services with resource parents. We are addressing any payment issues that may, arise. We are, sharing information with them so they can provide care for the child. And we do that in collaboration with the resource parents.
Okay.
Is that often at the caseworker level?
Yes, yeah, that would occur at the caseworker level.
So on page 2 of your response, and this goes back to an earlier question, you note OCFS would also note that the first 5 months of 2022, OCFS has fielded over 200 constituent inquiries from families, mandated reporters, et cetera. Each inquiry is assigned to the appropriate staff person for follow-up. This is what I think we've been trying to get at for a while. Is like, is there a way for at least a human being to confirm receipt of a report? I understand an automatic generated email, but that's almost the same as a black hole. A person from OCFS saying, I can't give you any confidential info. I can tell you that your report's received and and we're working on it. Is that what you're saying is occurring here with these 200 constituent inquiries? Like a human being is calling?
So I think there's a difference between a constituent inquiry and a mandated report.
Okay.
First of all, just want to
Correct.
point that out,
Correct.
but
Okay.
So the mandated reports are those that come in through child protective intake with allegations of suspected abuse or neglect. And then the constituent inquiries are, they could also be allegations of abuse or neglect that then we route to our child protective intake. But often they are individuals calling in with questions, concerns, feedback about a specific case or case process. And so we have, a staff person in our office that, fields those, gets them to the correct people, either within central office leadership or within the district leadership, who then do follow up with those constituents to better understand their questions or concerns and then respond to those.
Okay. Since you cited the 200 figure, do you have a sense out of how many constituent inquiries were received in that time?
I think that's 200 constituent inquiries. There were, I would imagine, many more other mandated reports. Is that, I'm sorry, Senator, is that your question?
I'm getting hung up because you noted mandate reporters here, so I presumed that's what we were talking about, but you're saying constituent inquiries is different.
Correct.
And what I'm understanding is these constituent inquiries, 200 of them received a live contact back, which is what I think many of us have wanted over the years. We want to improve the faith in the system. And so I'm just trying to understand what that 200 number means. And what I heard is most get a call back, but not all. And in this paragraph, 200 constituent inquiries got a call back. So is that all of the constituent inquiries got a call back or most?
So all of our constituent inquiries would have had probably a call. Some may have an email if they've only provided an email address, and we may email them back to those email addresses. And sometimes that results in a call as well. So these are different. The child protective reports. So if someone is calling Child Protective Services, they obviously speak to a live person and have that direct contact. If they are at this point making a report through the portal, it's my understanding that we are calling those individuals back. And especially where we're first rolling out the system in order to make sure that we have all the information that they wanted to report and that there's no additional questions about what's been reported.
Okay.
With the new system, reporters are entering information. And so there may be fields that they missed or fields that we may have questions about what they entered. And so we're calling back to make sure that we understand the information that they were intending to report.
Okay, thank you.
Can I just clarify?
Sure.
So the mandated reporters could be part of the 200, right?
Correct.
Among other people that you've listed here. But separate from that, we have mandated reporters who could have called in or could have used the portal.
Correct.
And I'm not asking you or expecting you to know how many people in 5 months used that. I'm just trying to get a sense of the percentage of what 200 is, even though that doesn't really give us good data, because that 200 includes families or other types of providers, not just mandated reporters. That's correct, right? I'm just trying to clarify who these 200 are. So 200 people got calls back or emails back, clarifying questions or just feedback. And they're part of that group of mandated reporters, but not all mandated reporters.
So I think that the 200 came in through the constituent services pathway. There's sort of two pathways to, provide, well, there are more, but for the average constituent, there are two pathways to reach out to OCFS. One would be the intake line, where you call specifically if you have allegation or concern of abuse or neglect. And then the other is constituent services. I know I get those and route those to OCFS through many of you. Those make it through
Some of
Scott
those
Perkins.
200 are probably sitting here.
So yes. So the 200 are those that come in through the constituent intake, and that may be a mandated report. It may be a follow-up on a mandated report. It may also be something else related to child welfare.
That's helpful. Thank you.
Thank you. Senator Bailey.
Thank you, Mr. Chair. So just going back to the follow-up with the person who reports suspected abuse or neglect, may be a mandated report or may not be. And I think you had mentioned something about your hands were tied in terms of getting back to them and doing follow-up. So two questions. The first is, what is the policy, if any, that the department has around doing follow-up? And secondly, I'm assuming when you say your hands are tied, that you're talking about the confidentiality statute, which, as I read it, does allow the department to get back to someone who has reported it, but all you can tell them is you didn't open a case. And so is that what the policy is, and is that the hurdle? So that's kind of a multifaceted question, but I'm just trying to dig back into what Senator Libby was talking about, which we have heard from a lot of reporters who say it feels like it goes into a black hole, and what we can do to address that. Thank you.
Sure. And I can answer, I think, the second piece, although I'd ask Bobby for the details on whether or not we can say whether we've opened a case or not. But yes, it's the confidentiality piece that would prohibit us from, oftentimes a teacher, for example, calls in a report, and I imagine, sees that child in school the next week, or and may call us to say, I reported this, did you look into it? Those are often things that we can't confirm or certainly tell them what decisions were made. So you're correct, that was what I was referencing, but Bobby may be able to talk more about specific policy on follow-up.
So in regards to telling a reporter whether we opened a case or not, I would need to go back and review the statute related to the specific language. One of the expectations that's outlined in policy is that when someone makes a report, that they receive a call from the child protective caseworker that's assigned to see if they have any additional information that they want to share. So that is one pathway through which someone would then be notified if we had opened a report based on open an investigation based on a report that they had made. Senator Bailey, I'm not sure if I understand your question related to doing follow-up.
So the way I read the confidentiality statute, that under discretionary disclosure, there is a provision that the department can make a disclosure to the reporter. But all they can disclose is that they did not open an investigation. And I think that goes to what you were saying, which is if you opened an investigation, obviously one would hope you'd be calling the original reporter. That's where you'd start your investigation, right? So they would know it's an investigation's been open because you're calling them saying, okay, we're doing this investigation. Can you tell us what happened? The optional discretionary disclosure laws also allows the department to contact a reporter to say you have not opened an investigation. So I'm just wondering if you do that, and or if there's a policy around when you do and don't do that.
We don't do that on a routine basis, no.
I was going to continue through Senator DeChambeau. Mike, please.
I like to follow. And the first answer was see OPEGA final report on Child Protective Services investigation, see page 72. Unless someone has a different final report.
Yeah, I think the electronic copy has
Mine
a
only
page
goes to page
72.
65.
I think what they're referring to here is page at the end, 2, 3, and 4. And this is just a function of how we print our books. So I think
Do you have a page 72?
no, they are numbered differently in
Oh,
the
they're
print
numbered.
version.
Are you serious?
Yep.
So you wrote 72 and it's somewhere else?
It's contained in the back, Senator.
It is?
There is a 4-page letter from the department contained in the back of the printed book.
Yes, that's what I was wondering.
The
Is that
bound,
it?
the bound book, yep.
Okay.
I apologize, it's 72 on the PDF.
Oh, okay, now I understand.
Sorry about that.
Okay,
I did not
so-
realize.
Thank you.
Sure. Um, Can you expand on question number 3, page 2 in your response? Question number 3 is, how is OCFS working to improve information sharing with the community institutions we referenced? I didn't really understand. I don't think the question was really answered in the printed response. So can you just, what we're trying to get at is what is OCFS doing now that's different than what they were doing maybe a year or 2 or 3 years ago with respect to these issues?
With respect to mandated reports of suspected abuse and neglect. Senator Whitty.
Yeah, and I'm sorry if we didn't write the question clearly, but we've heard testimony over a period of years that OCFS does not engage in a lot of back and forth communication with these community organizations. And so I'm asking, what is OCFS doing to change that dynamic, that feeling that's out there among all the mandated reporter communities?
Thank you. So I think what we were highlighting in our response is that OCFS is responsible for the more mandated reporter training that is delivered to those individuals. And so we do that by having an online version of that training. We also have trainers that can go to organizations and provide that training. We're often asked at conferences to provide the training. And we also do train the trainers for organizations. So an organization may not want to have to rely on the department every year to train their staff. So they will have one of our staff go and train. And that's one of the ways that we're disseminating and interacting with stakeholders around the requirements for mandated reporters. And then we, again, cited the online portal, which is another pathway for people to make reports. And one of the things that we had heard from different stakeholders was the length of time I have to sit on the phone or I'm required to call back. And so this was one of those strategies that we were able to build within the new information system to streamline that process for mandated reporters, which was to allow them to be able to go into the portal, make a report. We had, some stakeholders that we met with that talked about what would that look like for you? What would be important? Some of the information was the ability to upload reports that they've already done, so they don't have to duplicate all that information. So, and maybe I'm still not understanding your question, but those are the ways that we've, specific to mandated reporting, interacted with those stakeholders and tried to streamline that process.
Okay, thank you. Follow up, Representative Stover.
Thank you, Mr. Chair. I interpret this question, some of the feedback we've had around, and it says information sharing, but I think about community engagement. So if you can describe any changes you made over the past 2 to 3 years, it's information sharing, but also it's about, they name above, we have the community institutions, but just how you're engaging with providers and others that may be providing mandated reporters that could include schools and childcare. But what are the ways that you think community engagement, whether that's at the central office, but at the district office level, happens with potential reporters, with potential mandated reporters and others? How do you think you're doing that?
So I think that there's a lot of pathways by which we do that. And I think, as I mentioned, I think that happens on the local level with our staff who are directly interacting with these individuals who are making reports or providing services to families. I think, through the constituent services pathway that we talked about. I think, and I can give an example where I just recently followed up with someone who reached out. She had used the portal. She had some concerns about some of the language that was written in the portal. So I directly followed up with her to understand what her concerns were. She was a school social worker. She had really valid concerns. I was able to take those back to our OCM team, our operational change management team, as well as Deloitte, who is the agency that has built our new information system. And so we're following up on that and looking at what changes we would need to make in response to that constituent's concerns that she and others within her school district shared. I think that happens at the local level, specific to cases and families that we're working on. Our program administrators at the local levels are involved in local community collaboratives and different groups where they're interacting with these stakeholders. And then at the statewide level, as I mentioned, with the citizen review panels, the child death and serious injury review panel, and the work groups that we're convening. I think those are the ways that we're hearing feedback and we're also responding to that.
Thank you.
Just a reminder for committee members, put your hand way out like this if you want to grab the attention of the chair. Are there additional questions in this subject, which is really around community engagement, communications, before we go on to the next section? Okay. The next section is outcomes. It's on page number 2. It starts with question number 5. I wonder if you can speak a little bit to the specifics that you referenced here in the linked child welfare annual report. So our question was, what is OCFS work? How is OCFS working to improve outcomes for children and families? And again, this is a question we've been engaged here for 4 years. What's been happening in the last year to try to address this big picture question?
So I don't have that report in front of me.
Okay.
Unfortunately,
We can move on.
did not bring a copy.
Yeah.
Well, I mean, I
Yeah.
do think that we can speak a little bit to the work that's been happening, generally to improve outcomes. So as you're aware, OCFS has been working since this administration took office on implementing the Family First Prevention Services Act. And I look for Bobby to kick me under the table, but I believe we were the first state in New England to have that plan approved by the federal government. And that is augmenting a number of prevention programs that the department either was already engaged in or bringing new programs to the state with additional federal dollars, such as Parents Partners and Home Builders at Triple P, which I'm going to forget what the acronym stands for. But the department also outlined a strategic plan for child welfare in 2019 that has been updated annually in that annual report, which is why we chose to link it there, because I think the annual report is 30 or 40 pages, but provides background on a number of initiatives, including implementing Katahdin, which is the new child welfare information service system, and reviewing all of our policies with the Muskie School and improving those with stakeholder collaboration. And I'm sure I'm forgetting some that Bobby can add, but.
Yes, so we've updated our training curriculum, both for new caseworkers and for resource parents, and we have rolled out implementation of that. We have.
Sure.
Sure.
That's okay.
No, that's okay. We have, I'm trying to think of everything that we're working on. We have implemented clinical supports for our caseworkers, a clinical support service.
Is that better?
Is that better, Senator Timberlake?
It's probably never going to get right for me.
You're welcome to move
Yeah.
to the open chair, Senator.
I'll try to project a little bit more.
I'm sorry.
So we have implemented clinical support services in each of our district offices, and those are services available to staff both for clinical consultation on difficult cases and also so that they can address the trauma and the impact of doing this type of work. We have, trying to think what else.
We might be able to stop there, but I think, the point is that all of this work, both to streamline the process, improve information, whether it's the internal information through child welfare information system or mandated reporter reporting, improving our policies or refreshing our training curriculum, is all aimed at making sure that we're providing a better service and the supports needed for families and children to have better outcomes.
Senator Khan, thank you.
Just circling back to what you were talking about with the Families First program, and I know that's, seems really good. We haven't really had, I think, seen improvements from that yet, would you say? And so I guess I wonder if you could talk to me a little bit about that. And then also, are there some there's a lot of metrics that are supposed to be met around that. And we seem to be going in the opposite direction of where we would like to go. I think we all agree. So are there metrics around that we're reporting back to the federal government, that they're, what's happening lately in Maine here that could impact our funding? Or just help me understand that program a little bit. I know it's I don't want to do a deep dive, but I do want to understand what we're reporting back, and definitely the fact that we're going backwards in outcomes and the impact that has.
Sure, and I'll ask Bobby to speak to the federal reporting, but I think the Family First challenge that you noted is that a lot of that work is still in the implementation phase. And so in fact, the supplemental budget passed just a few weeks ago had some of the funding needed to start up some of those programs. And so it's new federal dollars. It's a program that was, I think 2016 or 2017 is when it was authorized by the federal government. And then the state needed to develop the plan with stakeholders to implement it. We need approval of that plan, and then we need to develop the RFPs to provide those services, award those contracts, get the funding for those contracts, award them, and then those services can begin to be delivered. And so, I think we're as anxious as anybody to get those services off the ground, but we're certainly not at a point that I think we can say that there have been distinct benefits from that programming, because much of it just hasn't started yet.
Okay, thank you.
Yeah. And I'm not sure if Bobby, you can speak to any of the federal reporting, or if we might need to get back to you on that.
I think that answer was sufficient. Thank you.
There will be federal reporting required as part of the
Right.
program.
Yeah.
And we can get you details if you'd like.
Yeah, thank you.
I should know this. Are there federal block grants tied precisely to this program that you're referencing, Family First?
So it's not a block grant, it's match. And so it's essentially, I should probably let Bobby say this, but I think this is the next sort of phase of Title 4E funds. And so similar to 4E, where the state puts up seed money and the federal government matches it, we have to put up seed money, which thank you for appropriating that. And the federal government will provide significant match to support that program.
And is the grant fund tied to performance metrics, or is it based on population, or how's that?
I don't believe it's tied to performance metrics. I believe it's tied to implementation. Although some of the metrics would be the number of individuals served through the services, the cost of providing the services in our community. There is a requirement that they be evidence-based or promising practices, or that there's an evaluation component tied to any services that states are going to roll out. So that is a piece of what the states need to be responsible for services that aren't on the clearinghouse.
And I think the amount of funds that we receive from the federal government is directly tied to what the state puts up as the seed.
Okay. Great. Question number 7 on page 3. What is OCFS doing to improve information sharing to make sure that caseworkers have all the information they need to ensure that children are safe and cared for? And then we've got some follow-up questions here, and I just wonder if you want to highlight some of your response that you've given us to question 7, the first part.
Yeah, so I would, thank you. I think I would highlight that the work that we've been doing since really September, when we received the recommendations from the Collaborative Safety and Casey Family Programs report, a lot of those were focused on those systemic factors. And so one was our partnership with behavioral health and mental health providers, and information sharing and building partnerships. So we worked with the Office of Behavioral Health to disseminate a guidance document that I believe we've shared with the committee, that outlines ways that we can collaborate, things that they can do, things that the department can do, and how we can make that a better experience for families. I mentioned the work group that I've been convening, and so we have been meeting at least monthly since that time, and really focused on understanding the different systems in which all 3 of those organizations operate, and how we can share information and what the barriers are. We've looked at what models exist for information sharing, as AG Taub cited, we looked at, what are the confidentiality restrictions with medical information? I think that was something that was mentioned earlier by the committee. And what are the federal, restrictions and laws? How does HIPAA play a factor in that information sharing? We've looked at the collaboration when law enforcement and Child Protective is jointly investigating cases and what needs to happen to improve that process. We have looked at, potential legislation that may assist with some of these issues, and are, I think, in the early stages of continuing to talk about how those processes may be helpful. We've talked about training processes that we've done previously. So we had what was called the cops and caseworkers training. And so we've talked about doing that type of event again, or convening all three of those stakeholders in order to, to have some common understanding and language. We've talked about one-pagers that we can put together that help guide, hospitals if you have to make a mandated report. We have also been working with the university to implement family engagement specialist positions within the agreement that we have with them. And those are positions that would help to guide training, bring that parent perspective to policies and practices, help us to identify and research evidence-based parent mentor programs that exist throughout the country, as well as leverage the voices of other parents, because that's an important constituency that we want to hear from.
Thank you. I apologize, committee, I have to step out for a Zoom meeting and I'll be back. I expect we'll be continuing for a while. So I'll see you in a bit. I'll turn the gavel over to Representative Stover.
Thank you, Senator Libby.
I might also add, just
Okay, sure.
in here, one of the questions, I think it was sub question A is, what are we doing to improve information sharing to ensure that caseworkers have the data necessary to decide whether reunification or placement is best for the child? And it's something that I bring up because I want to make sure that we're all operating from the same understanding. And I think it's important that the committee knows that these decisions are not made unilaterally by not only the caseworker and their supervisor, but by OCFS. Both removal from their parent's custody and reunification involve a court order and a decision by the court. And so that does not change whether we need the information to make that decision, of course, but the way that question was phrased, I just wanted to make sure we had a shared understanding of what that process involves.
Thank you for that. Do you want to add anything to that on A?
I think the only thing that I would add is that the information sharing becomes so critical so that we can put together our statement of facts that then goes to the court, either in support of removal or in support of reunification or not. So so that is really important as we work with our courts and our other partners.
Thank you. Senator Timberlake.
Thank you, Madam Chair. And thank you for being here. The question I present is to follow up on question A is, I think the additional information I would ask for in the future, one of the things would be that if you was going to break it down between the caseworker, the supervisor, and up through the system, at what percentage of input would you think that the caseworker has for their recommendation of whether the unification should be taken or the child should be taken away? As I listen to people talk, one of the things that I seem to be a consistent message that I'm hearing is, and I don't know if it's true or not, so I'm just asking for additional information, is that that the people that are in the field and the foster parents or the parents, they're not always being heard. And I wondered what percentage do you think the caseworker, if he comes in and says, I think this parent is a great parent, or I think this parent is a bad parent, and what percentage does that weigh in on whether this child is removed or not removed? I think it's something I'd like to know into the future of what's your guesstimation of how that would break down all the way up through the chains of command, all the way to the court. I know the court gets the final say, but the court takes its guidance from the ad litem and everybody else through the system. So I just like to have the breakdown of how you feel that breaks out. Thank you.
Yeah, absolutely. I know we can give you at least some sense, if not a firm number on how often the court disagrees with a recommendation from OCFS. And, I think the caseworker, their supervisor, and other staff at OCFS, recognize that not every decision is going to be supported by every party in the case. And that's, perhaps that's an understatement, I imagine. In most cases, there are folks, at least one person who's involved in the case who disagrees with the outcome. Of course, that's never the goal, but I don't know, Bobby, if you have additional comments on what we might be able to provide there, but I imagine all of it we'd need to follow up with you to give you specifics.
Yeah, I mean, in order to provide a percentage, I think I would want to sit down and sort of think that through. I mean, what I can say is that the decisions are not made independently by any one person within OCFS. And the caseworker is responsible for gathering all of the information. They have a very critical role in this process, bringing that back and, in consultation with their supervisor, really determining, is there additional information we need to make this decision? Do we have enough information? Are there things we should have explored that we didn't explore? And does this reach the threshold for OCFS to legally and per our policies be able to determine whether a child needs to be removed from a home or not due to child abuse and neglect, and ensuring their safety?
Senator DeChambeau?
Yes, thank you. It follows with this, but it's something last night when I was reading some of the questions that we are submitting and these responses, I stopped at that term or that sentence. Data necessary to decide whether reunification or foster placement is best for the child. And I said, I wondered if that was properly stated. There is reunification and there's termination of parental rights, both of whom, I guess, those two columns, foster placement can occur. I mean, you remove the child and then the determination is, are we going to reunify? So foster placement belongs there. They've removed the child and the other result could be termination of parental rights and a child might be in foster placement there. Am I reading that? Isn't there two ways you can go? Again, the business, and there's the criticism a lot. People were used to the child's mistreated, end of story, we're talking a long time ago, and termination of parental rights. Incarceration used to be a reason to terminate parental rights. Now it's not. And then the criticism is there's too much reunification and too quickly. But why is termination of parental rights not in all those questions? It just says reunification or foster placement. Is there an answer to that?
I hope, I don't mean to be flippant. These are the committee's questions. And so I'm
Yeah,
not sure, but
so that's what I want to know. I first thought it was our question. So it was us using that terminology.
Yeah.
But okay,
But
I am making sense, right?
You're making
Okay.
absolute sense. And I think that's how we interpreted all of these questions, not necessarily
Okay.
verbatim, just reunification
you.
or foster, but outcomes more generally.
Okay.
And
thank
I
you.
also think that, I think when I was reading the questions, I was thinking foster placement, meaning removal. So not an alternative permanency
Okay.
plan to reunification.
So it's terminology again. I mean, okay.
Yeah, that's what I was thinking when it said foster placement. We certainly have other pathways to permanency for children, which would include, reunification, termination of parental rights, and adoption or permanency guardianship.
Thank you.
I think I thought it was a focus on reunification for these questions.
Okay. Thank you.
Others? If we could just move on, I think we've spilled into B, but you mentioned the OCF website as a resource. to look at the policies, but do you want to speak to what factors are most relevant in making a determination of reunification or foster placement? What are those factors you look for?
Yeah, so we're looking at whether the parent has made sustainable behavioral change to address the circumstances of jeopardy. So we're looking at what's changed from the time that the department got involved and there were safety concerns to the point in time that we're looking at their progress or lack of progress. And so we look at, you know, their participation in services and progress that they've made there. We'd look at the status of visitation and, you know, how have the visits been going? We're looking at, even outside of that, are we getting reports of behavior that would not provide safety for a child? So are we getting ongoing reports of, you know, substance use activity? Are we getting reports that they're in recovery and they're, you know, testing clean from substances and doing very well in their treatment? And so we're really looking at all of those different factors when we're making the decisions about whether children should be removed home, and this and the well-being of the child as well.
And back on to C, is there data that OCFS can provide to GOC regarding how the decisions are made and where children are placed and how those decisions impact well-being? Do you want to speak to any of this since we're not looking at the websites?
Yeah, so I think that on the OCFS website, as well as in information that we presented to the committee prior, we have outlined the placements where children are placed when they are in DHHS custody. We have the highest percentage of our children placed with relatives, and we have for many, many years exceeded the national average on that. And that's our first and primary placement option, is to keep that child connected to their family system and to identify a safe and appropriate relative that they can be placed with whenever possible.
Thank you. On 8, an examination of the child fatalities list shows that most had passed referrals for mental health and/or substance abuse services. How was it determined that the services were successful and therefore those children will return to a safe home? Will there be any changes to how that is determined that a home is safe?
I think
How it is determined.
a lot of that goes back to what Associate Director Johnson just outlined around how decisions are made, whether reunification is something that the department would recommend. You know, how is the individual, well, let me take a step back. I think the bottom line from what we just discussed is that it really is case specific. Each case has its own challenges and dynamics. And so we look at those to say, you know, was substance use the number one factor? Is that person participating in whatever their recovery activities may be, whether that's substance use treatment, whether that's mental health treatment? Are they meeting their goals? You know, is the are they able to take care of their child or children in a way that was determined they couldn't when the decision to remove was made? But I don't know if you have anything to add, Bobby, beyond what we just discussed.
I think that, you know, we do use the structured decision-making tools to help guide those decisions. We are looking at safety and risk, and we reevaluate that throughout the time that we're involved with the family to see if there's been changes in those determinations. We rely a lot on our partners, our stakeholders, so our, you know, substance use disorder treatment providers, our mental and behavioral health providers, our schools, and our law enforcement, and we're gathering information ongoing to determine whether there are any continuing or further concerns that we would need to be concerned about related to putting a child back in that home. And so we, you know, are looking at all of that. We also, you know, I think underneath that foundation is that we're providing training to our staff on how to use those tools, but also how to understand substance use disorder and the recovery process. We have a training coming up for staff to provide that again for them so that they can understand how that information fits into the analysis of progress for a parent. And so we're training our staff, and then we're also partnering with community providers and others, families themselves, their extended families, and the resource parents or caregivers to be able to have a comprehensive picture of the functioning of that family in order to inform those decisions.
Senator Timberlake.
Thank you. I hate to be a bother, but I'm gonna have lots of questions because I
Okay.
just do. I think the question that I'd ask for you to try to get back to us, do you have a policy of how often these caseworkers or these groups are supposed to be visiting? And, you know, with each one of these parents or foster parents, as these children are moved around, are they supposed to visit them every 30 days, 15 days? Is there some policy? I don't ask for it today, but if we could have that into a future to what the expectations are and how often are those expectations being met?
Yeah, we can certainly provide you with the written policy, but Bobby may be able to give you some, an outline of what that looks like.
So at a minimum, we expect that our caseworkers will do monthly caseworker contacts with parents, children, and resource parents. And so at least on a monthly basis, they're meeting with them.
And does that mean a telephone call or does that mean an actual visit? I think would be my second follow-up
That
question.
would be an in-person
In person. Okay,
in-person
thank you.
contact. We also expect that they are convening family team meetings at least quarterly. So that's bringing together all of those individuals that are connected to that case that may either be a support or providing services to the family. We are also checking in with service providers at least quarterly, more frequently if the case needs dictate that. If a child is in child home placement with a parent, we have increased expectations for contact with the family and with the providers during that period of time. And so I don't have that off the top of my head, but we can get those expectations to you.
I appreciate it. And I just would like to know if that's being done at all times or if there is times that it's, you know, because what you hear and sometimes what's really happening is sometimes two different things. You know, I'd just like to know if they are meeting every month with these people or it's happening with telephone calls because they're overworked and don't have enough people. I mean, there's reasons. I understand that.
Correct.
So I just would like to know what the percentage of that it's happening every month.
Yes, and that is data that we track, so we can provide that.
Senator DeChambeau.
It's not all my questions, it's just the questions I hear from others that triggers something. In follow-up to Senator Timberlake's question, you know, when I talked about it last time, when you have a caseload, you think that you're gonna treat them all the same. Is there a tool? I hate to say, use that word even, geez. I'm gonna have a bunch of tools in front of me. Is there an assessment that does aid the caseworker after you tabulate everything, that this is a family I need to call every other day or see every week? I'm going by history now. Do you have something like that in DHS, a tool that would help objectively the caseworker? And conversely, if you do have a tool, everything's on the computer, a manager would be able to see if they're following exactly what the recommendation is that you must see this person every week, at least once a week. Am I making myself clear on that?
Yes, I think I understand the question.
Yeah.
We don't have a tool. Certainly the structured decision-making tools help to identify what's the, you know, high, moderate, low safety
I'm gonna
concerns.
stop you. If the tool tells you there's a high need of services, that in itself would tell you. Or if they're actively using drugs or something like that.
Correct. So those tools would help to guide those decisions. And they would be then made in consultation with the supervisor. So the supervisor and caseworker would meet, they would prioritize workload. They would review information that we may have, new information about a family's functioning that, you know, so they may say, you know, you're not required to see this family again until June, yet we just got this information. And so you need to go do an unannounced home visit tomorrow, the end of the week. and so they're making those decisions on a case-by-case basis in consultation with the supervisor.
As an aside, you kept mentioning community providers. I just want to throw out the people who are incarcerated, who are parents. DHS is working with them. Frankly, I can say, I think they're the most successful because it's a confined environment and they're in programming. So I thank the caseworkers who go that extra mile to come into the prison environment. Thank you.
Thank you. Yes, we do work with incarcerated parents in similar ways that we work with parents that aren't incarcerated within the restrictions that they have.
Great.
And even a bill that your committee, Senator, passed this year is going to help us get additional data from
I didn't hear that.
a bill that your committee 1721 passed this year is going to help us get additional information on parents with children involved with child welfare in county jails. So it is an important source of collaboration for us, and we appreciate that.
Representative Rada. Isn't it working?
No, the green light is lighting up, but not the red. Can you hear me?
Do you want to?
As long as you can.
Oh, try again.
Try turning yours off now, Mark. Oh,
There
there we go. Okay, it wasn't me. So the child fatalities list, I know as I went back a few years and I noticed a lot of referrals for mental health, substance use services. Some of the deaths were accidents, but a lot of them were unsafe sleep, which can be influenced by substance use. Many of them sadly were suicides, but we can't tell. I couldn't tell from the data whether the substance use services was that a referral for the parents of the teenager or for the teenager himself. But I guess where I'm going with this is if it's determined that substance use services are necessary, does that necessarily lead to a recommendation that the court remove the child until the parent has successfully completed substance use treatment? Or
That is far too in the weeds for me. So
So not necessarily. I think it depends on the level of the substance use issue, the impact on the child. We do that analysis about, is the child safe with this caregiver or not? Are they in services? Where are they on their pathway to recovery? So we're looking at multiple different factors when we make those decisions about whether a child can remain in that home safely or not.
I'm trying to think of a way it would be possible for a newborn to be safe in an environment where their caregiver is using substances. I'm seeing a disconnect there, I guess. I can't imagine how they could possibly be determined to be safe. Maybe it's because I haven't seen the decision-making tool.
Yeah, I think that we get reports where we get a lot of reports where substance use is a factor. And I think, some of it depends on the substance that they're using, when they're using it, how it's impacting their behavior, how it's impacting their child. So there absolutely are families where we would not want them caring for an infant, a newborn child, given the level of substances, the substances they're using, and the other circumstances in which they're engaging in. And then I think so there may be, a caregiver in the home that isn't struggling with substance use disorder, that is a safe person in that home. And the other caregiver is engaging in treatment. So I think there's a lot of different factors that we're looking at when we make that decision to ensure that child is safe going into that home.
Okay, but in these cases from this list, that determination doesn't appear to have been correct. So are we constantly improving strategies and determinations.
By list, are you speaking about the dashboard?
Right,
That's
I
yeah.
believe so. There's a list that goes back to, I think, 2007.
Yeah. So I do just want to clarify what the dashboard, so the child fatalities that are listed under substance use or substance exposure are fatalities that happened as a result of access to substances. It doesn't necessarily mean that the department knew or that there was even a referral for substance use treatment prior to.
I
the
think I'm
fatality.
talking about a different list
Okay.
then.
Okay.
Right. And I'll send you a link to
Okay.
it. So we were making sure we're talking about the same thing.
Yeah, absolutely.
But it shows the list of the dates and, you know, what was done. You know, there was a visit. There was a referral for mental health service. There was a referral for substance use service, and then child fatality. And it was,
So one of the things I would say about that list is that some of that history that's outlined could have happened prior to this child being born and in subsequent involvements that the department may have had with the family. So those were the referrals that was made. They may have at that point resolved those issues if the department was involved. And then this child was subsequently born.
okay, it wasn't clear to me from that list, but I can certainly understand.
Yeah, so some of that history goes back many years for those families, and some of that includes history from when they were children that may have been connected to them now, and now they're adult caregivers or parents.
Okay, thank you.
We're happy to talk about that more, either here or offline when we have the list in front of us.
Sure, thank you.
Moving along. Earlier, we discussed this next issue on 9, and it's about, you have established a working group to address or to solve the problem of caseworkers getting access to medical records. As we know, HIPAA is a pretty high standard to pass through when you're asking for medical records. Can you give us an update on the status of that project? And also, I know we had some legislation that we passed recently that helps to the medical and law enforcement, enabling legislation for them to work on sharing information. So if you could just tell us more about how you're getting medical records, has access improved? What are still some of the barriers to that, if any?
Sure. And I can talk about the legislative sort of landscape or statutory landscape, and Bobby can jump in with anything else. I think the bill that you're referring to is LD 58, which we worked with the Criminal Justice Committee on to access investigative records in limited circumstances when that can be helpful. I should say law enforcement investigative records when we are doing our own investigation. And there is the working group working with law enforcement and medical providers, as well as the Assistant Attorney General and OCFS. And I think it's possible, if not likely, that we'll come to the legislature next year with a request for statutory change to overcome some of the statutory barriers we've found. I don't know if we have specifics on that yet, or if there's additional work that should be noted.
I think just the work that I outlined earlier that committee is working on.
That's encouraging to have that addressed. So I think we can move right along. And now let's talk about the KC Family Service Report. What have you implemented from those recommendations? If you want to give us a little bit about that, please.
So we have all of the recommendations are either in process or have been implemented. These work groups that we referenced in question 9 are 2 recommendations. One was related to behavioral and mental health providers, and the other was to convene a work group with law enforcement, medical professionals, and OCFS. We also, and this was also noted in the ombudsman's recommendations, have implemented the safety science model. And so we've hired 2.5 staff as safety analysts in that process. We've been working with a multidisciplinary team of, we have staff internal to OCFS, and then we also have the Child Welfare Ombudsman and Dr. Amanda Brownell, who is the child abuse pediatrician within our state, that sit on that team that looks at all of the cases that have been reviewed that fit the criteria for a systems analysis, and they determine which cases will move forward for an analysis. And then we have implemented, I think April was the first month where we implemented the systems mapping and the full process review on those cases. So we are well underway in that process. We've presented about that to all of our child welfare staff and some other stakeholder groups. We also presented to the Child Death and Serious Injury Review Panel to talk about where there may be any intersections between the work that they do and ways that the work of this team may be able to enhance the work that they do. We have, I'm trying to think of all the recommendations. We've been working on a proposal for improving the after-hours children's emergency services system. We've convened a work group of, we had convened a work group of staff, and we brought them back together to talk through, now that the legislature has appropriated the lines, the additional staff lines, what's their vision about what this position, these positions would look like. And so we've been able to get feedback from our district management team, which oversees our district offices, and representatives from each of the district offices, caseworkers, supervisors, in order to help shape that proposal. And so we're working on taking all of that information and developing it into a proposal that will then work with human resources on. We have another work group that is working on looking at the investigations policy, the timelines to completing an investigation, as well as the activities that are required to complete an investigation. One of the things that we want to avoid is any duplication, and that would be either in that investigation process, or we may have things that are done by intake that then our investigation staff are doing again. And so we want to reduce that expectation within our policy. So we've been looking at those expectations.
I believe one of them was related to the family team meeting policy, which was updated last fall.
Correct. We updated and rolled out our revised family team meeting policy in November, and we have been doing trainings on that for staff, both on how to facilitate those meetings and build the team, and then also the expectations, the policy expectations around the team. So we're trying to give them the skills and the knowledge of the policy. We
this might actually be a good time too to go back to a question. Unfortunately, I think it was Senator Libby's question, but related to what documentation is provided after a child fatality. And I know the child death and serious injury review was referenced, but safety science has changed the way that we are doing that. So I don't know, Bobby, if you want to talk about, just to jump back to the safety science piece a little bit, talk about what that looks like now.
Yeah, so through that process, we do what's called a technical review, and that technical review is done on all child fatalities, near fatalities, serious injuries, and ingestion reports. And so whenever central intake or child protective intake receives a report of that nature, our safety science team also gets that report, and they do what we call a technical review. And so they go in and they're looking at the history for that family. They're looking at the current circumstances, and they're providing that information to management so that we can then look at what needs to happen next. They're also identifying learning points. That's the term that's used within this model. So learning points that we may want to further explore. And that can be either, specific to OCFS practice, or it could be a point where we were collaborating with a stakeholder. I'll just use law enforcement as an example, that there may have been challenges. And so we want to dig into that to better understand that. So this model is really allowing us to look at these cases through the lens of both internally and externally. How are we partnering, and how are we doing our work, and what are the opportunities for improvement?
I have one other clarifying question about the MDT process, and that you're underway in the first of several in-depth reviews. How will that information roll out? Will there be a press release? Will there be, once you've completed the first grouping, will there be any sort of information disseminated to the public in aggregate, not about cases, about findings, recommendations, or changes, policy or program changes out of the findings of that MDT? Or is that part of the plan? I guess I'm trying to understand what happens after they complete these in-depth reviews, what happens next?
So once the reviews are completed, quarterly, they put together a trend report. And that we haven't talked about, whether that will be used for external uses. That is one of the places that we started to have that conversation with Child Death and Serious Injury Review Panel about how that could benefit some of the work that they're doing. We don't have a plan at this point for public dissemination of that information, but it certainly will be used internally to look at policies, practices, and to inform the work groups that we are involved with. So if we see a trend related to medical law enforcement and OCFS, it would help inform that work.
Thank you. Senator Kine.
Thank you. So the cases that are chosen to be reviewed, is there any other criteria, or is it only death, serious injury, or ingestion?
It's child fatalities and near fatalities with history over the last 3 years.
Okay, and did you use the word ingestion, or did I make that up?
So the technical reviews that we do, so there's a technical review that happens on all child fatalities, near fatalities, serious injuries, and ingestions. The cases that then would subsequently have a full review would be the child fatalities or near fatalities.
Okay, so the difference there is a technical review versus a full review.
Correct.
And the only different criteria is the ingestion criteria.
Or serious injuries.
Oh, and serious injuries. So
Correct.
death and near death or near fatality.
Correct.
Fatal. Okay. So the technical review, how many do you foresee then doing? Like, is that quite a few?
So the technical review occurs on any report that we receive in a month that is a child fatality, near fatality, serious injury. So we have some serious injuries that aren't near fatalities or ingestions. So that happens on any report that we receive during a month, and our safety analysts complete that. And then for the smaller subsection of child fatalities and near fatalities that had prior child protective history within the last 3 years of that, receiving that report, those would go on for a more broad review if it was selected by the multidisciplinary team.
So not everyone goes for a full review.
Correct.
They only those that get chosen by this multidisciplinary team that you've outlined here.
Correct. And
So,
some months, there's only 2 cases that meet
Okay.
that criteria. So the multidisciplinary team will, the safety analysts present their cases. They will determine that there are learning points or issues that they would like further clarification on, or they feel like, could benefit from a systems review. And so those cases are selected. If there is a month where we have multiple cases, then not all of those are selected. Some of them may be backup cases in case for some reason we have additional capacity to do the reviews, or we can't move forward with a case. And so, so the multidisciplinary team is the team that is selecting those. And we have, that team within OCFS is made up of our medical director. There's a regional associate director. There's a training and policy manager. There is our violence prevention program manager. Trying to think who else sits on that team, our quality assurance person. So those are the lens through which we're looking at the information to say, what could we learn? How could it benefit the system? And do we agree that this should be a case that gets the full review?
so when you say the safety science analysts present the review, is it this 2.5 people here that are they're the initial intake, they're the initially looking at the cases, and then kind of, I guess, sifting through them to see whether or not they send them on to the multidisciplinary team? I'm like trying to making sure I understand the flow here of.
So the safety analysts do all of the technical reviews on every single one of those cases. And then the their supervisor, in consultation with myself and the medical director, are determining which cases would meet the criteria for near fatality. And unfortunately, child death is defined. And so all of those cases that are determined to meet that criteria and have the history within the last 3 years are presented to the MDT. So the safety analysts aren't screening out any of those. It's happening with the program manager, the medical director, and then I usually just review it to see if I have any different thoughts on that analysis.
So, and I know they're fairly new. When were they hired and how long has this process been happening?
They were hired, so 2 of them were hired in January, and then 1 was hired, I think, in March. The part-time person was hired in March.
So since January, these technical reviews and then the full reviews have been happening.
Starting in February. So
Starting
they
in
did
February.
training, and then we started looking at and we started doing the technical reviews on cases in February. So we hired them in January, trained them, and they continue to get ongoing training and coaching. in the
From
model. From Collaborative Safety.
Okay. And then, so when do you expect your quarterly trend report?
Probably June or July is when we would have the first one.
Okay. And you're considering, and that's something I think we would like to see as a committee here. So I guess maybe just make note of it. We can circle back to that at another time. Okay, thank you so much.
Senator Timberlake, and then Senator Bailey.
We will get to all the questions, I'm sure. Thank you, Madam Chair. Just wanted to clarify, again, it looks to me like both the case reviews and the MDTs that we're talking about here, that other than the Child Welfare Ombudsman, it's all done with internal people, that it's all DHHS or Dr. Brownell, who works for DHHS, even though she's technically works for Spurwink, but but there's no outside.
So our 2 external partners would be the Child Welfare Ombudsman and Dr. Brownell. And then we also have our coaches and trainers from Collaborative Safety at this point that are part of that process.
And who pays them?
So at this point, KC Family Programs is supporting that implementation. And then it would be the department.
Okay. So was there any thought given to other, you call them external partners? My concern is, I mean, I think this all sounds wonderful, but it doesn't get to the transparency, the accountability, the, kind of being able to peek in a little bit as to the internal workings of the department. And so how was that decision made, I guess, in terms of keeping it so insular?
I do want to say, I think that Ombudsman is certainly an independent voice that you hear from and is part of this, but Bobby can speak to whether there's been discussion otherwise.
Yeah, so I think we made the decision about the composition of that team in collaboration with the developers of the model. So Collaborative Safety and what has been MDT, what have MDTs looked like in other states? The Child Welfare Ombudsman wanted to be part of this process. And so we really worked with, where can we integrate her into this process and have her be a part of that. And then we, in addition to our own medical provider, we thought it would be really important to have the lens of Dr. Brownell, who is seeing the majority of these child death and near death cases as well. And so we wanted to have that lens as that initial decision is being made. When we do the systems mapping, if there are learning points that include other stakeholders, we can also bring them into that process. So we've had law enforcement participate in that process. Right now, we are working to have tribal child welfare participate in that process. We have had staff from the alternative response program participate in that process. So we're certainly not closed in that process to other stakeholders being part of it. I think some of it is finding that relevancy. And so that MDT could also make recommendations. So the child welfare ombudsman could make recommendations that, it may be important to have someone from public health nursing or someone from, law enforcement participate. And so we would, take those recommendations.
Senator Timberlake.
Thank you. And that's why I was at Senator Bailey goes first, because she asked my question much more eloquently than I would have. So I only asked the first part of my first question. My question is, and maybe you've discussed it when I wasn't in the room, and I apologize if you have, is what are we doing for prevention to make sure we don't ever get to the point where we're getting the ingestion and the accidents to happen? There's got to be some monitoring, and I've read the book through here trying to find that question. So maybe I need to propose that question somewhere along the way. And I may have missed something. So that's why I'm not, but I would like to know, how are we improving our preventiveness from letting this happen, letting us get to where we're doing these investigations?
Sure, thank you. And I think it's a very big question, but for the top line, I think referencing back to the new services that we're working to develop to work directly with individual families. Prevention is multifaceted, and I think there's a lot of work that we can do as a community to make sure that we are creating, cultures and support systems that help prevent in the broader sense. But in a lot of situations, prevention can be as sort of individual as the family itself, and making sure that the specific caregivers have the tools that they need to care for their children and provide them with their basic needs and more. And so there are a number of programs that we are just on the verge of implementing related to the Family First Prevention Services Act funds. There's the Parents as Partners, additional home visiting dollars that will increase the amount of home visiting and sort of individual support to families that was appropriated in the supplemental budget. And there's a high fidelity wraparound program that OCFS is in the process of implementing, and that's on the children's behavioral health side, but impacts a number of the families that are involved with child welfare. And Bobby may be able to speak to some of the other specific programs, but I think there's both the communication and the broader work that we've been discussing around sort of that community level prevention, and then there's the specific family level prevention that I'll ask Bobby to speak to.
So I think at the family level, we're looking at making sure that individuals are connected with those services that could benefit their family before it becomes a child welfare intervention issue. We've done work within the department. We have a state agency partnership for prevention, and we have looked at through all of the different divisions within the department, what are the prevention services that are provided. We have recently rolled out Access Maine, which is a website for individuals, providers, others to go to understand what the service array is within our state. We've been looking at the service array in partnership with other stakeholders, and that was how some of the decisions were made about what services we felt like we needed to either further expand within Maine or bring to Maine. So home builders prevention and home builders reunification is one of those services. And so prevention is going to work with families involved with child welfare before their child has been removed. And then the reunification service is going to work with families where a child has been removed in order to strengthen them to be able to be reunified if that's successful. We've looked at the service array for children and for adults. So that's been one of the things that we've looked at, and where are those gaps, whether it's related to substance use disorder or children's behavioral health services, and how do we make sure that families can access those, that families know what those services are and then are able to access those Those were two of the themes that came up through our stakeholder meetings and the development of the Family First Prevention Services Plan, was that families don't know that these services exist, and then they also don't know how to access them. And so we've had a lot of efforts around how do we make that information more visible to families and more accessible.
I think to just a quick follow-up, and from my observation and sitting here listening, what you explained is very complicated. And we talk about we're implementing these and we're going to implement this. I don't think the average person that's dealing with this, because I sure the heck wouldn't, that's dealing with this, talking about all the things you're talking about, have a clue of all of these programs that you're talking about and how they're going to be implemented. But when are they going to be implemented? I think my concern is we talk about this is going to be done, and when, and I guess I'd ask you to report back to us at what date all these programs are going to be implemented and when they're going to start working. Because, you know, we're working on this, we're working on that. I hear that, it's all good news. But I'm an old-fashioned farm boy. I'm pretty straightforward. And I set deadlines to when things are going to happen and when it's going to be implemented. And I want to know when that's going to happen. I think that's the thing that I ask. I don't want to hear anymore, we're working on this or we're working on, I want to know, what did you set for a deadline of when this is going to happen and how is it going to happen? And how are these people going to understand it once you get it in place? Because you talked about a whole bunch of things in there that I've sat here for a year on, that still some of them go a little bit over, but that these children, I'm concerned about how we protect these children from preventing this from happening. I don't want to get to why we're investigating this child overdosed or got into some drugs they shouldn't have got into because a parent was still taking drugs and they weren't supposed to be taking drugs, or anybody that was, or why are we there? I want to know what we're doing to create that so it's not happening in the first place. Other than telling me about the programs we're implementing, when are they going to be implemented and how does it stop it? I think that's what I would ask for in the future.
Yeah,
And if I could just clarify, in the most recent session, we passed 9 different pieces of legislation. And I think that some of the things that you've referenced are things that we recently passed and funded. So maybe in laying out, like the senator suggested, we highlight those as initiatives that are coming because they just recently passed and got funded. And then the other things that you're concurrently already doing, we could just show that. I think it would be helpful to see, even though we did before Lucia left, she did a really great job at highlighting the pieces of legislation and what those initiatives were. But now that we've actually successfully got some of them rolling out, when we think some of those things, like the RFPs will be out in September, and contracts will be completed in, I'm not going to pick that date, another date.
I'm liking this though.
But you know what I mean? It's like, so we pass the legislation, the money becomes available in your coffers. You've got your RFPs rolling out, those contracts will get awarded by X date, and those services that we're talking about are no longer sort of, we knew Families First was coming. There were pieces of that are Families First. There are pieces that are not Families First, but what's that look like? When do we actually think, I don't want to use boots on the ground, but when do we actually think the things we've imagined to happen and wanted to happen? And I say that mutually, from sitting on HHS, from sitting here, from knowing you, we've all wanted these things to happen. And so now that we know some of them can happen with funding is pretty important. What do we think that timeframe looks like?
Yeah, we can certainly outline for the committee sort of an expected implementation timeline for each of those. There are always those asterisks around when contracts get approved and through the loops of state government. But it has felt like Families First is coming for a very long time. And, that is the nature of the way that these funds have been allocated to the state and the way that we need to apply for them. And but with the supplemental budget, we're closer than we ever have been, and we can certainly provide that a specific implementation timeline for the committee, or expected implementation timeline. I also wanted to address your comment about, you hear about all of these things, but how, what does that mean for an individual? And I think the way we talk about them in here is to provide you with an understanding of what services are out there or in development, but it's certainly not the way OCFS operates or the expectation that a parent needing these services would, one, have the capacity and the bandwidth to go and seek them out, or two, necessarily know exactly what fits their needs. And so I think what that really looks like is either a caseworker being involved with the family or a community provider saying, the parent saying, I'm having a hard time, responding to these challenging behaviors of my child, or someone identifying that dynamic in the family and saying, parents as partners would be a really good tool for you, an assistant, for you and working with that family. And so all of the tools we talk about, Access Maine, to provide the sort of, again, list of resources is, certainly beneficial to those who have the capacity to go out and search for the resources, but it's certainly not the only way. And there's a much sort of warmer handoff, they call it, with families that are seeking these services than certainly the way we talk about them in here.
Well, I really appreciate it, and I'll drop with that. But I think of implementation as being the thing that I see. We talk about all these great programs that are out there, and we've been talking about them for a long time. And when the wheels of government sometimes don't spin as fast as we like, but I think we have to stop using that as an excuse. And I think all of us sitting around this table agree to that. I don't think there's not one person sitting here that wants to see one more child have even a boo-boo on their finger. I mean, we all feel that way. And so if there's something that we need to do to help you to get that implemented, I think we need to know about it, because we have the ability to do that too. We're here to help, not just be a hindrance. But I think that this has to happen now, sooner rather than later. And I don't know, it's frustration in me because I hear it's coming. It doesn't. So I like to set goals. And so that's why I ask if we can have it right. Thank you very much.
Yeah, thank you. Thank you, Senator. Senator Keim, did you have your hand up?
I did actually, and I think I'll just follow up with OPEGA staff after. Thank you.
Okay. Any others? Moving us along, if you could update for us how you have worked to improve communication between at the caseworker level, caseworker supervisor, up to the office director, up to the commissioner, and all the way through. What steps have you taken to address communication and improve communication?
Sure. So we have multiple different pathways for communication. Since Dr. Landry has joined our team, we have done town hall calls, or we actually started prior to the pandemic with in-person visits to each of our district offices, and we would do those on a regular basis where Dr. Landry, myself, the regional associate director would go and meet with all of the staff in a district. Since 2020, we've been doing those virtually. We look forward to the time when we can get back to in-person and have a plan to try to get out to all of our district offices over this summer. We have a casework advisory team and a supervisor advisory team that meet monthly with the regional associate directors. And there are representatives on that team from each of our district offices. So we have caseworker representatives and supervisor representatives. We convene a senior management team meeting quarterly, and that is made up of managers throughout OCFS. And so that's another way that we're hearing feedback about the concerns, challenges, successes of their staff. We have a virtual suggestion box, and so we get to those. When we get anything through that suggestion box, that goes to the appropriate regional associate director. So whoever is assigned to oversee that district will get that, and we'll do follow-up. What else? I would I would say, myself, the regional associate directors and Dr. Landry at times will try to go out to the district offices if we're in those areas. So not a scheduled town hall event, but if we're going to be in a certain area of the state, we will look to stop into those offices. There haven't been a lot of staff in those offices at this point, but we look forward to that changing over the next several months.
Senator Brooke.
This was kind of my question, so.
Okay.
I think the thing that I ask in this when I look at it is having some communication with some of them along the way. And what we heard in the Casey report and some of them was that supervisors at some point don't feel as if they're totally being heard up the chain. And I think my question is, how are we implementing that these people that are reporting to their supervisor, it's moving up the food chain, as I call it. What have we done to implement that, to change what we've done in the past? It sounds like here, what I heard was what you've been doing for the past 2 or 3 years. That's not addressing a problem that's been persistently there and is there today. That, our communication is better. I think the one thing that's been, at least that I think I've heard, I don't want to put words in anybody else's mouth, but there's been a lack of communication up the chain. And I want to know what we're doing different after the Casey report that changes that. Having a town meeting or inviting all the staff in to sit in a room and supposedly have a conversation isn't my isn't my solution of how you improve communication. As someone, it's one-on-one conversations with these people and knowing who your employees are from the top down through. And I don't expect the commissioner or Dr. Landry to know everyone, but as the supervisors go down, there has to be personal relationships. And I'm concerned about that. And I'm wondering how we've changed that over what we've been, because all I hear is the same thing he was doing prior to. That's not a solution. In my Casey's report says there is a lack of communication, and I want to know what we've done to fix that.
Yeah, I think some of the ways has been by engaging frontline staff in the work groups that we've been convening. And so as we have further developed our policy development process, or some of the work groups that I've mentioned earlier, where we've been working on the investigation policy, the time frame for investigations and whether there's duplication, we made sure that the largest representatives in the room were caseworkers. They're the ones that are doing the work on the front lines. They're the ones who are looking at, when I do this, I also have to do that over here for the same activity. And so, that's an example of where we made sure that their voices were represented. I think, whenever we have a new cohort of caseworkers come through, Dr. Landry welcomes them in their first week, and then I get to celebrate their graduation with them in their last week. So that's our chance to welcome all of those new staff to the agency. So I think those are some of the ways. We also have, we've been coaching supervisors around building relationships and how to build relationships in the current climate that we're in with a pandemic and with a lot of staff working remotely or being out. Like, how do we do that different? So we've been looking for strategies that we can help to improve that, because I think some of that feedback has come during this time when staff are feeling more disconnected from their supervisors and their program administrators. We've had a lot of new staff on board, and they haven't had the benefit of being in the office with their peers and their supervisors in the ways that they were prior to the pandemic. And so we really tried to look for what are those strategies, and returning to the office, for supervision and for unit meetings and district staff meetings as quickly as we're able to do that safely in order to build those relationships.
One quick follow-up. Actually, it's 2 questions, but I'll ask it in one. When do you see everybody returning back to the office? And how often do you follow up after they graduate? Do you have communications with each one of them once a month, once every couple of weeks? You personally having that communication, in touch with them, that they that there. It'd just be a question I ask.
So I certainly open the door for them to reach out to me, and when I'm in the offices, I try to make those connections. We do have a recruitment and retention specialist who is the first person within our organization they have contact with, and she helps to onboard them, and then she's following up at regular intervals with all of those new staff to get feedback on, you know, how's it going? Is there any needs that you have? And so she gets a lot of information. So it's not myself directly, Senator Timberlake, who does that, but we do have a staff person who does that, at least for their initial onboarding period.
Yeah, and I, before I move on to the return to work piece, I think too, communication can always be improved internally. But as we've discussed, the decision-making model in OCFS is really a team-based model. And so there is a lot of communication that goes on between the caseworker, supervisor, regional associate directors, and, if there's specific concerns about, anonymous or not about communication, we are happy to discuss those. But I do just want to point out that, it's not, again, unilateral decision-making that happens. And then on return to work, this is, OCFS falls under the Bureau of Human Resources, and that's DAF's. I believe we're working on a return to work policy for the department for this fall for complete in person, but I would defer you to DAF's for the more substantive plan for state workers. And those plans are certainly being sort of personalized by office and at the office, the department, the office, and the team level too.
Oh, Representative Fay.
Thank you. I know I'm kind of over here in
I
the
know
willy
you.
wax. So following up on Senator Timberlake's questions around communication, what I'm curious about is if there's like a specific problem solution pathway. So say a problem is identified either by a caseworker or even by someone utilizing the services of OCFS, either on the foster side or child protective side. How does communication impact, and what is the pathway for getting those problems solved specifically? And I think it's probably a really big question. I think I ask it more because I'm hoping that we're thinking about this. I think we all hear from our constituents about specific concerns, and then would love to see how those are actually being solved in real time. Maybe a little bit related to the communication question, but I think it's also a two-way, maybe even like a multi-level intersection where we're all trying to get this information both imparted and have it fed back to us.
So I think there are, I think I mentioned some of those pathways. I think that, caseworkers will bring concerns to their supervisors. They can bring them to their program administrators if they're not comfortable bringing them to their supervisors. They have the human resources and the union pathways that concerns are sometimes raised. They can bring it to, myself or the regional associate director or Director Landry. So I think there's multiple pathways, and we do get those, calls or those emails at times. They also come in through the suggestion box. So at times people will bring concerns about practice or policy. Sometimes it's specifically about a practice that they perceive as happening in a district. And so the regional associate director who oversees those districts would do the follow-up directly with that person. And then also, to understand what is the district practice, and are there any changes, adjustments, anything that needs to be made? I think we talked earlier about some of the ways for external stakeholders. So we have the constituent services pathway that we get concerns. I get direct emails, Director Landry gets emails, and we are responsive to all of those. So we're, if we get a concern, we're looking at what district, is responsible for this case or working with this family. And then, and we're asking for updates and information so that we can determine the appropriate level of response. So should it be Director Landry that reaches out, or myself, or should it be the program administrator who's closer to the work of the district and can respond to those concerns? And so we, through all of those different pathways, are making, decisions about how to be responsive to our own staff and to constituents. Things come through our central intake occasionally. So, the Child Protective Hotline, we also get other types of calls. And so that's another way that sometimes things get brought forward. Anything additional you can think of, Molly? Or
I think that's it. Are you looking for more specific, like individual, like a foster parent has a concern, or did that address here?
Well, and I appreciate the question, and I've heard from families in my district that have specific questions, and so I guess, it kind of goes back a little bit to that sort of black box thing where, we give you a problem, and I don't necessarily know that we're always part of the solution, but I think helping our constituents know that they're being heard, and that there is whatever the situation is being addressed in a way that's timely, and that meets their specific needs. And so I just am curious, what that pathway looks like. And I think you sort of answered it.
I think the answer is that there are multiple pathways, and there are certainly those that are more ideal and those that are, more take a winding road to getting their answer. I think certainly for those involved with a specific case, members of the public, whether they're resource parents or whatever, reaching out to their caseworker supervisor is often the most direct way. And then if that is, unsuccessful, reaching out through other pathways. But I do think, that feedback is important. And as Bobby illustrated, there are many ways to do that. And it, but depends, I think, on the specifics of the case and resources available to them. But
and I would also just add to, there may be some issues that are litigated through the court process as well. And so there's times when we may, have a conversation with someone, but it really is an issue that the court or their attorney can advise them on, because we don't give legal advice. And so we may direct them to those individuals for further guidance.
Senator Bailey.
Thank you, Madam Chair. Quick, easy question. The virtual suggestion box, can that be anonymous, or does the person have to identify themselves?
So they identify themselves in the identify themselves in the district that they work in, and then they identify if they want a response or not. So they have the option of just saying, I just wanted to bring this to your attention and don't require a response, or please get back to me.
So follow up. So is there any way for a caseworker to voice a concern anonymously?
That is a great question. I'm trying to think about, because I know I've got them before. I'm trying to think about how I've gotten them. I think I have gotten them in the mail, honestly, that it's come in that type of format. So not through an email, because they all have state email, so that would identify them.
So cover that. Representative Faded, that covered the communication question as well. I'm going to take one more question, and then I'm going to realize we've been sitting since 9 o'clock and take a short break for folks to stretch their legs. Number 12. In 2018 and 2022, the OPEGA reports highlighted serious deficiencies in casework supervisor oversight. What have you done to improve oversight of casework supervisors. Can you tell us about that, please?
Sure. I think what we've done is really outlined in the response. We've been working in collaboration with the University of Southern Maine as part of the policy and training work to develop a supervision framework that includes core competencies for supervisors. It includes policies related to supervision. It includes coaching and guidance. It also includes a supervisor academy training. We've had that in place for a long time and developed that in collaboration with the Butler Institute in Colorado. And so that's I think it's a 9-day training that supervisors go to over the first year of their tenure as a supervisor to help build skills related to, administration, education and support, using data to guide decisions. And so we've been doing all of that work. We also regularly convene statewide supervisors meetings. And so that's another pathway for supervisors to provide feedback about topics, feedback from them for themselves or for their staff related to practice and policy.
Yes, Senator Bailey.
Thank you, Madam Chair. So I might have missed it, but I didn't hear anything about oversight of the supervisors. I heard a lot of training, support, which is all important, but the question was improving oversight of caseworker supervisors. So maybe I missed it, but what's the department doing in that specific area, oversight?
Yes, you did not miss that. I did not respond specifically to that. So they're supervised by our program administrators or our assistant program administrators. And so they have regular supervision as our caseworkers do. We also have the quality assurance process, which is looking at the decision-making that occurs on cases. And that decision-making is a team effort, as Molly had noted, between the caseworker and the supervisor, and sometimes the program administrator and others. It may involve the assistant attorney general as well. And so that's where the oversight really happens, is through the program administrators and the assistant program administrators, and then the quality assurance processes.
And yes, Representative Fay.
I got lonely down here, so I thought I'd start asking questions. Following up on something Senator Timberlake mentioned earlier about goals and timelines, et cetera. I appreciate all of this work being done, and it says work is expected to be completed in 2022. And I missed, I don't know if you said when, or if you had a sense of when you might be ready to roll this out and implement this. And if you could add that maybe to our timeline.
Yes, I can.
Thanks.
Some of this has already been achieved and other parts of it are in process.
Seeing no other questions, we're going to take a 10-minute break, partly to let both of you have just a breath of air and maybe a drink of water, and we'll reconvene in 10 minutes. Thank you. Senator.
Just want the record to show I offered gavel. Representative Stover. All right. I'll call the meeting back to order. Thanks for coming back, everyone. I think what chairs and leads have chatted about is a plan for the rest of the day. We've put forward 38 questions. We gave the department, I think we gave them to them on Thursday, which was just a couple business days to prepare answers. They got us responses last night. And I think there's interest in the committee members digesting the responses a bit more. So what I propose is we go through half of the questions today, which would give us, I think, through question 19 would be halfway. And then we would stop there for the day. We'll continue the questions at our June 15th meeting, continue the second half. So these folks can get back to the rest of their busy day. And then after we finish with these 19 questions today, our committee will have a little discussion on our next steps. So that's what we proposed. Seeing nodding heads. So we'll proceed in that fashion.
And
Representative Stover.
perhaps that will give our committee too, since we haven't, because we gave such a short amount of time to get the questions answered, and then we've had a short amount of time to digest. We can digest this a little more before our next meeting and send any comments or questions on the particular questions.
Right.
If that's okay with the staff.
Okay. So with that, we left off, we completed question 12.
Yes.
So we're now on to question 13. So question number 13 for the department, what has OCFS done to ensure that caseworkers are protected when raising concerns about supervisors overriding concerns about child safety? The department did give us a detailed response, so I'd welcome just a high-level summary of that response or anything you'd like to add.
I think I would just add that, as we've mentioned, that those decisions are made in a team process. There is also the ability for the caseworker and or the supervisor to ask the program administrator to be part of that decision-making process. And there are actually times outlined in our team decision-making protocol when the either the program administrator or even the regional associate directors are required to be part of that decision-making process. And so there are pathways that staff can take in order to share that they disagree with a decision. And sometimes that will result in what haven't we considered or what other information might we need to gather in order to make a better informed decision. Sometimes we do disagree about the pathway to take. Sometimes we also involve the Assistant Attorney General in that process, and so they will help guide our decisions in cases where there is disagreement, or in cases where there's agreement. We also consult with them if we feel that's necessary.
And on the protection piece of this, it also goes back to, I think, a question Senator Timberlake asked earlier, which was about, and Senator Bailey, about providing anonymous feedback. And I want to say digital Dropbox, but I don't think that's the virtual Dropbox, virtual suggestion box. Thank you. Is not anonymous. We did neglect to share that workers can provide anonymous feedback either through human resources or through the union. And so that is a pathway for them to provide concerns, either specific or policy related, in an anonymous fashion. And I just wanted to come back to that briefly.
Thank you. I'm just catching up here. Just give me 1 second. Okay, so when a complaint is received through HR and the union, are you able to disclose to us sort of the management next steps, that maybe next 2 or 3 steps, on how that concern, can you give a bit more specific detail about how that might be addressed, how it's documented, and that sort of thing?
Or when it comes to HR or the union.
Yeah, I'm trying to get a sense of, what happens when the complaint is received through either of those venues, HR or the union. How does the OCFS leadership operate once that complaint is received.
Okay. So I think that, HR obviously will determine what to bring to the agency for a follow-up. Myself and the regional associate directors meet every week with our human resources staff person. So we have an ongoing, communication around whatever issues are coming up. And so if those are brought to our attention, I think a lot of it is guided by the HR process, depending on what the complaint is. And so if it's policy or practice related and something that we are able to then do direct follow-up with, we would do that with getting information from the staff person and following up, with the supervisor or the program administrator, whoever may be appropriate to figure out what the resolution is. There's also circumstances where it's going to go through an HR process, so we're informed about it, but we don't take action steps to address it. We either do that in partnership with HR, or HR does that completely independent of us. And so I think there's those multiple different pathways, Senator Libby, depending on what the concern is that's brought forward.
Okay.
I just had
Representative Stover.
one clarifying question. Does the department participate in labor management meetings? Do you have labor management meetings these days?
I
might have to get back to you on that.
Yeah, I don't know the
Thank you.
answer to that.
Okay. I'm not seeing any other questions or comments on question 13, so I'll move on to 14. How often does OCFS evaluate the screening questions used by the caseworkers?
So those structured decision-making
Yes.
Tools. So those are, so any of the evaluation process occurs in collaboration with the developers, Evident Change, and we have a contract with them for ongoing support and technical assistance. Some of that support includes work groups, so developing work groups where we're bringing staff together and we're getting feedback about their use of the tool, anything that's confusing about it. We have done this process with our child protective intake screening tool. So that was the initial tool that we rolled out in 2017. And we convened a work group over the end of 2020 and into throughout 2020. And then I need to look at my dates because I'm getting my years mixed up. So we convened the work group at the end of 2020 and we rolled out the changes in 2021. And so staff were involved in informing those changes. It's also informed by national feedback that they're receiving. So if there are, items on the tool that need to be updated, with race equity stuff or some national, larger issue, broader issue that's happening, then we would incorporate those changes into that process. When we initially rolled out the tools, there was a process for ensuring inter-rater reliability and validation of the tool before we implemented it. So we had a pretty extensive testing process that occurred before we rolled out the tool. We continue to look at the fidelity to the tool through the quality assurance process. And through that process, we're getting feedback about, is the tool being used? Is it being used in the way it was intended to be used? How is it used to guide decision-making? And so we have the feedback through that process as well.
Thank you. You were present for the discussion this morning around the tool as it relates to access to committee members being able to have under executive session, being able to observe the tool in process and receive presentations. So I wondered if you're able to comment on that interest of the committee.
Yeah, so I have done demonstrations of the tool before. I did the safety and risk assessment tool. I demonstrated that to the Child Death and Serious Injury Review panel. They were interested in understanding, like, what does this mysterious tool look like? And, what are the mechanics of it in the process. And so that is something that OCFS has done in the past.
Okay. And so if a letter were sent by this committee to OCFS requesting one of those presentations in executive session, how would the department respond?
I think we would be happy to share as much of that, tool through a demonstration as we can. And we need to review any specific requests with our AAG and look at the contract, which does with evident change, which is specific about what we can share and what we can't. But yeah, certainly if the committee's interested in a demonstration, we'd be happy to do what we can there.
Follow up on that? Representative Stover?
Thank you, Mr. Chair. I would just, if the department is restricted from doing it, I'm just wondering if evident change has a sort of a dog and pony show when they're selling the software that they would be willing to. I'm picturing they're going to pop up on that screen and give us, like, it's going to click through a bunch of slides and show us exactly how this works. I mean, as another option, if that makes it easier, because they must have some sort of sales initiative for this, but it would be really nice to have the department do it because it's more personal.
Yeah, we can definitely work on what that would look like. And I think I also heard somebody mention, it might have been Senator Bailey, wanting to, or maybe I shouldn't attribute, I'll get it wrong, but wanting to speak to the person who teaches the tool. And we've already, been discussing how we can make that happen to the person who does the training for our caseworkers, who can, answer questions and provide you with that background. So we'll work on what that can look like and yeah, let you know.
Follow up?
I know question 20 is very related to this, and I don't think we're going to get there in our 19 questions, but I don't want you to leave feeling like you don't have the information you are looking for on the SDM tool. So if it's the pleasure of the chairs, maybe we could go out of order to do that one now and then go back to where we were.
I'm not hearing any objections, so let's go to question 20.
So I'll ask.
And
Bobby
the
to-
question is, for the benefit of the public, what data can OCFS provide on the SDM tool conclusions that are overridden by supervisors? And that covers from initial assessment to closing of a case.
So we have the information for the screening tool, and we're collecting the information about the other tools where an override is possible. With the intake screening tool, we completed 29,443 screenings. And of those, 3.6% had an override. 208 of those were to override an initial decision to screen in a report. And 906 of those were to override a decision to screen out a report, which means that we then opened it for investigation.
If you could just pause for a moment. We may not be familiar with that verbiage, but 208 overrides. We're saying we screen them in, so we're going to consider this child case, and the override was to take them out of the system. Correct. And not do the evaluation. And then 906 were going in the opposite direction, where a caseworker said, we're not going to investigate, and a manager said, we are. Is that correct?
Correct.
Okay.
And I think this is what you mean, but I just want to be precise. You said we're not going to do the evaluation, and I think more specifically, we're not going to do an investigation. The SDM screening is the evaluation of the report. Oh, I apologize and move the mic over. I just want to make sure we're clear. I think this is what Senator Libby meant, but he said not to do the evaluation, and an evaluation of an intake is what the structured decision-making tool does. The decision would be whether or not to open an investigation, which is the more in-depth follow-up with the family. So the evaluation has been complete. The determination, the tool spits out, for lack of a better term, its recommendation. And then the supervisor and caseworker and anybody else on the team reviews that and either chooses to override, like in these cases, or not.
Thank you for the clarification. Representative Fay.
Thank you, Senator Libby. Just curious if the 3.6% override rate is comparable to what happens in other states, or are other states keeping track of that type of information? I'd be curious about that.
Yeah, so this is one of the metrics that states measure, and we are within the range for overrides that evident change would expect us to be in. They expect to no more than 10% overrides within a child protective system using this specific tool, and recognize that there's no tool that can account for every single circumstance that may come forward. The other thing that I just wanted to say to Senator Libby is that it may be that the caseworker does the screening tool and thinks that there are reasons why an override should be done to screen in a report or screen out a report. And so they may take that recommendation to their supervisor. So it's not always just the supervisor reviewing what the work that the caseworker has done and then making a different decision. Sometimes it's the caseworker bringing that decision or that recommendation forward.
Do you have historic data on that? I mean, is this something you regularly collect over the years, or is it new?
We've looked at it just a few times and we've tended to be around the same level. So we have a fairly low rate of overrides.
You're saying with, say, the last 3 years, you've had the same rate, or could you give an approximate time period?
I can get that for you. I don't have the information off the top of my head. So we looked at it for calendar year 2021. So we could look at it for we looked at it, I think, in the first year that we implemented, and it was a similar similar data.
That's adequate for now. Thank you. Senator Khan, followed by Senator DeChambeau.
Okay, just a quick question. When you say, so in your answer to that, the last portion says other SDM tools. And I'm just wondering what those other SDM tools means.
So we have implemented what they call a suite of structured decision-making tools. So within that suite of tools, there's 5 tools. So there's the intake screening tool, there's a safety tool, a risk tool, a risk reassessment tool, a reunification tool, and a case planning tool. So we looked at it for that first tool, and we're working with evident change to get the data for the other 4 tools that and for any of the other 4 tools where an override is part of the process.
Okay, yeah, that would be interesting. Thank you.
And you said you are collecting that data
Correct.
for the remaining tools. Thank you. Senator DeChambeau.
Thank you. I just want a clarification. Is only the supervisor can override? Is that correct?
The supervisor would be the one to make that final decision, yes.
Make that final decision, but can a caseworker request an override? And
Yeah, so a caseworker could recommend an override.
Yeah.
And then would share their recommendation with the supervisor. A program administrator could also be involved in that decision if there were questions.
Okay, thank you.
Other questions or comments on question 20? Okay, if we go back to, I think we completed 14. 15 has been answered here. The answers feel similar to what we've heard earlier in the conversation. So unless there's interest, I'm going to skip over this one.
I would
Yeah.
note on this one briefly that the supplemental budget included additional funding for the Kinship Navigator program. So that will be expanded through Adopter and Foster Families of Maine. And that is certainly the services to provide the kinship navigation to those families, but is another feedback loop for us. So we look forward to implementing that.
Thank you. In question 16, the department is referencing us back to answers they gave for question 13. So I guess I would ask members, is there any follow-up you'd like to ask on this question? Okay, seeing none, we'll move on to question 17. Again, for the benefit of the public, I'll read the question. When caseworkers go outside the office to report to the ombudsman's office, the child welfare ombudsman's office, it seems that they frequently experience retaliation both internally and in the larger professional community. What is OCFS doing to end this culture of retribution and encourage transparency when cases are not being adequately followed up upon? So I'd ask the department to respond to that question, highlight anything you'd like in the written response.
Sure, I think I can certainly start and just share again the multiple feedback loops that we offer for folks. And I think certainly if staff feel that there's retaliation, at least internally, that those other human resources is certainly an avenue for those concerns as well as the union. But I'm not sure if Bobby, you have any other additional background.
So Director Landry, myself, and AAG Gannon meet regularly. We meet monthly with the Child Welfare Ombudsman. We review all of the reports that she produces, and within that, we're able to look at whether there's any themes specific to concerns that are raised about personnel, either from an outside constituent or from an internal staff person. Those are brought to my attention. That's part of the process and the flow chart that we have outlined. And then I would follow those pathways that we've talked about earlier for doing follow-up to ensure that those concerns are followed up on, that the staff person is heard, and that we're addressing anything that needs to be taken care of.
So what about a situation where you've got a caseworker who's making a complaint to the ombudsman regarding a supervisor decision? I think one of the pieces of feedback we've received from the public is it's that dynamic, the supervisor caseworker dynamic, where the caseworker has no place to go. And you receive that complaint, you at your level in OCFS leadership, and you say you deal with that issue, but how do you ensure that the supervisor is then not exerting retribution on the caseworker? Like, how from your seat do you ensure that doesn't happen?
From my seat, I would ensure that that wouldn't happen, through the supervision that occurs with that supervisor, with making sure that that caseworker has a pathway to continue to express concerns that would come directly to the program administrator or the regional associate director or myself. I can't recall a time when I've had an issue brought to me from the Child Welfare Ombudsman that was an internal complaint. But I would handle it similar to the external complaints that we receive, where we want to build a bridge and not create further division within those relationships. And so we would really be looking at how do we resolve that issue in a way that protects that staff person, that is clear and direct with the supervisor, and there's a path and a plan for how that's going to be addressed, and then allows for follow-up check-ins, ways that we can continue to make sure that there isn't that division between the caseworker and the supervisor.
Thank you. Follow up. Senator Kime.
I'm wondering how often this occurs. Can you give me any idea on how often we're having, a caseworker is disagreeing with their supervisor and then bringing it to someone outside?
Outside of the agency?
Well,
or-
right, to the ombudsman or reporting it in some way in the agency.
Sure. So I can't recall a time when the ombudsman has brought that particular scenario to me. I have had concerns brought forward from caseworkers, either directly to myself or through some of those other pathways that we've described. I don't think it's a lot of the time. I wouldn't be able to put a number on it, like a percentage. I think that we have processes in place, and whether that's internal within OCFS, within DHHS, or within human resources and the union, that those are really those avenues by which those issues get brought forward and resolved. One of the things that I think OPEGA had noted in their report is that one of the things that caseworkers cited as, I'm not going to cite it directly off the top of my head, but as one of the most important things for them is that relationship between themselves and the supervisor, and the support that they receive in that relationship, and that was one of the reasons that they tend to stay within the organization. And so I would say it's a minority of the time that those issues are coming forward. And when they do, we certainly take steps to understand the concern and then follow up on it.
Okay, thank you.
Thank you.
I think also, and I'll want Bobby to comment on this, I think, but, you know, I imagine it's not uncommon that there are different perspectives on a case. But part of the team-based approach to the decision-making in those cases is reviewing those and walking through them. And so there are, I imagine, a number of situations where that discussion starts with people having divergent opinions. But, you know, I think from our perspective, you know, often there's an agreement made through those processes to move forward.
Yeah, I would agree with that. And I think that that's, you know, that's one of the reasons that we have a team decision-making process. And so that when, you know, staff that aren't agreeing about, you know, what needs to happen next in serving a family or on a specific case decision, they have the ability to bring in others with a different lens that can help to, again, identify like what more information do we need? You know, what's the support for your decision? We'll talk about, you know, how does that fit with policy? How does that fit with statute? And I think there's times when, you know, the caseworkers have legitimate concerns and reasons why a certain pathway should occur with a family. And there's other times when they may learn some information about the analysis that's occurring that would make that different for them. You know, we always try to resolve those in the best way possible so that we have a team decision coming out of those meetings. And I'm sure that there are times when, you know, people still struggle stepping out of those meetings with a decision or a path forward.
Thank you. Any follow-up from committee on question 17? Question number 18, what is OCFS doing to address the changes recommended by the Ombudsman's Office and state oversight panels? And in your response, you reference a memo to the committee. I didn't get that far in reading this last night to open up that memo, but can you speak to that? Can you expand on that answer a bit more?
I think I could speak to a couple of them. I don't have the memo directly in front of me either. I know, you know, I think one of her concerns was related to investigation practices. And so we've been looking at, as I said, the timeline for investigation, the redundancy. We've had conversations with her about safety planning, and as part of the review of this policy before we finalize it, looking at that component too, to make sure that it's addressing the concerns that she's brought forward. She also recommended that we implement the safety science model. And so we have implemented that, and she's been part of that process. I'm trying to think about other specific recommendations. I think those are the two that I can speak to off the top of my head, Senator Levy.
Okay. I just want to look at our staff for a moment. Was that memo included in our packet? It's okay. I didn't know if it was a quick answer or not.
Yeah, I think that
we received months ago.
We received lots of letters, so I'm not sure which one.
The ombudsman's report.
Yeah, I'm just trying to figure out if it's in our packet or not.
If it's here today.
Yeah, there are two memos from the office, one on March 22nd. The other.
No, I don't believe it.
Okay, all right.
I think one of the additional pieces that she had highlighted was training for staff. And so we have been working with the university around our training for new caseworkers and then also for supervisors and building that supervisor framework. That was the third thing that I recall that she was, and we have a, you know, the legislature has recently appropriated a 4th regional associate director position that will be specifically responsible for policy and training and helping to strengthen that framework.
Follow up from committee. Okay. Question number 19, what is OCFS doing to build on its existing quality assurance system to identify, practice concerns in a timely manner and create opportunities for feedback, mentoring, and training.
This is a long response, so I'm going to try not to read it, but there's a lot of information packed in here. So we have implemented additional quality improvement activities as part of an extension to our federal program improvement plan. Due to the pandemic, states were allowed to apply for and granted an extension on those plans. And so we have increased the number of cases that are being reviewed by the quality assurance team. And then we've also been doing district-specific reviews of cases with quality improvement program specialist staff that we have. So we've increased the number of case reviews. We've also looked at, and they're looking at key child welfare practices. So they're looking at family team meetings. They're looking at the development of the rehabilitation and reunification plans. Are we engaging with families and other supports to develop those? We're looking at the monthly caseworker contacts with children and parents, and are we completing those and what's the quality of those? And then we're providing feedback to the district. So they are receiving individual feedback at the caseworker and supervisor level, and then also district feedback about any trends they're seeing from all of the cases that are reviewed for their district during that time period. We also, through the safety science model, as we talked about earlier, we are reviewing, doing a technical review on all of the reports that involve a child fatality, near fatality, serious injury, or ingestion. And so that gets, at a minimum, that technical review that we can then look at. And then some of those cases through the multidisciplinary team process would be identified for a full system review.
Thank you. How would the GOC committee, looking at the quality review issues that were raised in the OPEGA report, how would we know things are moving in the right direction? Like what can you show us? Because some of the QA analysis that was done suggested like less than half of these cases are properly documented, less than half are followed up on in a timely fashion, and those kinds of things. How are we going to get a sense that things are moving in the right direction?
So I think that would be through, ongoing, the way that Director Landry and I receive that information is through ongoing data reports through this QA and QI process that we're receiving. And I think the other pieces, are we meeting the strategies and the goals that we outlined in so there's two pieces. One is, are we accomplishing the activities that we had outlined within our plan? And then the other piece is the data and outcomes related to that. Within the Child and Family Services process, there is a certain period of time to accomplish the activities. And then there's a ongoing period of time past that date to measure the outcomes related to the implementation of those strategies. And so I think through that ongoing measurement process is where Director Landry, myself, and this committee would see progress.
Okay. At the next meeting on June 15th, could you show us either a summary of the report you're receiving so that we can compare that data to what we captured in the OPEGA report?
The data report.
Yes. Thank you. Follow up, Senator Khan.
So what you wrote here, and then when you were just talking, you mentioned several times doing things by district. And so it says here, this includes a review of a random sample of cases. And then what the reviews are focused on. And then when you were talking, you also talked about doing things by district. So I just wanted to understand that a little bit better. Are you picking random samples of cases in each district? Or are you doing reviews of districts? I just wanted to understand that, like sort of the breakdown, and because I'm curious what the differences are you're seeing in the districts as well when you're doing this.
Yeah, so we did two things. So the quality assurance team did a random sample of cases from each district.
Okay,
And
so it
then-
was by each district. Okay.
Mhm. Yes, and then the quality improvement team did a random sample by each supervisor. So the work that they were doing by district looked at one investigation from each investigation supervisory unit, one case from each permanency unit. And so we were able to then look at, it's a very small sample, but it gave us at least a glimpse into, what are we seeing when we're looking, not only by district, but by supervisor. And all of that information is put together and shared with the district. And the meeting that involves our quality assurance staff also involves our training team, so that we have that full continuous quality improvement process where we're looking at, are there policy issues, are there training issues or needs that we need to provide additional support to a district regarding.
So when you get these reports, then are you seeing differences by district?
So I haven't seen one of these reports yet. They go to the regional associate director. The report that Dr. Landry and I get is about our Child and Family Services Program Improvement Plan. So it's at that higher level. And that includes some trend data as well.
Trend data, but not broken down by district, you're saying?
We have the measurements by district, and I would have to look back to see if we get the trend data by district and if we have the ability to pull that out of the federal system. I believe that we do.
Okay, and then you haven't seen any of these reports yet because it's again another new program that's being implemented.
Correct. So the quality assurance reviews are incorporated into that data. The quality improvement team that's doing the district specific by supervisor reviews, they started doing those reviews, I think, December. And so then putting together that information and sharing that back to the district.
Okay. All right, thank you.
Additional follow-up? So we've made it through the group of questions we're going to take up today. We will complete the second half at our June 15th meeting. One question, I don't recall if it's in this packet or not, but I did want to ask before we leave. Do you have more recent data on vacancy rate of caseworkers and how many you've hired since the last time we asked that question?
I don't have that at my fingertips, but we can get that information that we provided before. One of the things that I would say that has been a positive trend over the last month is that we've had 5 different staff reach out to us to return to employment with OCFS. I think that is directly related to some of the changes that we are anticipating making, related to our after hours coverage and some of the things that we've been sharing with staff and involving them in the development of.
Thank you. Are there burning final questions that members would like to put on the floor before we release these folks? That was the right way to say it. Before we thank them for their participation today. That's what I meant to say. Okay. There was one from this morning, and this is the last one. The Deputy AG mentioned there's a child death, serious injury, internal case review tool. Are those still used by OCFS?
So I was gonna say, we did talk about that a little bit earlier, Senator
was
Libby,
out.
when you were
Okay,
out. So we
I'm sorry.
do a technical review process now.
Yeah.
On child fatalities, near fatalities. And so that has replaced that child death, serious injury case review document that we were doing. And so now we have the technical review document.
It's part of that safety science process.
Okay. And I'm sorry if it's repetitive, but can you just briefly tell me what's in that technical review?
So whenever a report of that nature comes in, it's assigned to a safety analyst who goes in and reviews the prior history that a family has had, looks at the current circumstances, and then also looks to identify if there's any learning points that we might want to follow up on. And then that is shared with leadership within OCFS and DHHS.
Okay, and that, those findings are captured in a memoranda? Is that fair to say?
In the technical review report. Yeah.
Okay, technical review report. And so if this committee were to draft a letter to the department requesting being able to observe, being able to read those review reports in an executive session where the material is brought to the committee and then taken back after the meeting is over, how would the department respond to a request like that?
Yeah, we would review any of those requests with our Assistant Attorney General and get back to you.
Okay. Senator Khan.
Just to follow up on that, there's the technical review and then there's the full review. I think there's many more technical reviews that happen and then only a few that go on for full review. Is that right?
That is correct.
Okay, so I guess we would need to discuss which of those we wanted to see. Okay, thank you.
Sounds like I left at an inopportune time. So the full review, is the full review triggered like in the case of a child murder? Is that a fair
Yes.
statement?
Yes, I can quickly explain that. So each month we receive child death, child fatality, near fatality, serious injury, and ingestion reports. And a technical review is completed on all of those reports that we receive in a month. And then any report that is a child fatality or near fatality with history with the department in the last three years is presented to the multidisciplinary team for consideration for the full review process.
And that group decides which cases get the full review.
Correct.
And who is in that group?
So that group has a regional associate director. It has the child welfare project manager who oversees the safety science process. The safety analysts participate and present their technical review or their cases. It also involves our quality assurance manager, our policy and training manager, our violence prevention manager, our medical director, our the child welfare ombudsman sits on that group, and the Dr. Brownell, who's a child abuse pediatrician in the state of Maine. So that is the team. I'm probably missing some of the OCFS.
Okay.
Oh, our children's behavioral health program manager also sits on that team.
Thank you. Senator Bailey.
Thank you. And I know the MDT full case reviews is fairly new. So to date, how many of those have occurred, if any?
The full review, I believe we have done 2. I think we did 2 in April and we did 2 or 3 in April and we have, I think, 2 scheduled for May.
Follow up, Senator Bailey. Okay. Senator Khan.
So I know that I have asked, I think it's a similar question, but I'm still trying to understand. Some of the technical reviews, even if they're not fatality or near fatality, do they ever get pushed on for a full review?
Some of those, so I think there would be a different pathway. So if they don't meet the criteria at this point, we haven't had any that have been pushed on. We could certainly make an exception if there was one that, you know, the team felt like we really want to have some additional review of this case. But all of those get reviewed by, they get shared with myself, with Director Landrace, and with the regional associate directors. So it doesn't just stop with the technical review. There is a pathway where there's some additional review by management, and we may learn from those technical reviews. There's a policy challenge or, you know, a training need or something that we want to follow up on.
So how many technical reviews have there been since you've started this process, which I think you said was February?
I do not have that number off the top of my head.
That might be helpful information for us just to, you know, I think this is a really good process, and we might be wanting to explore it a little further. Thank you.
So if this committee were to ask for the full review, there would be a total of 5 of those reviews in the department's possession. And then if we wanted to look back prior to February, would we be requesting an internal case review tool? Is that a fair statement?
Yes, so prior to February, we would have either had the child death and serious injury case review or a briefing memo that would have been completed on particularly those child death cases.
Thank you. Last call. Thank you very much for joining us today. Appreciate it.
Thank you.
Misplaced all of my papers. Agenda. Okay. Welcome back, Scott. I believe I've failed to introduce one Opega staff member. Is that right? Who's present with us today? Maybe not. No, I got Amy. Everybody here? Okay, never mind. Okay.
That was hours ago.
All right. Everybody's forgotten. So the staff are here. Our interim leadership team is here to help us with our next step. And I guess I'd like to hear from committee members if we're ready to have discussion about the request of the department, what we want that to look like for document review in executive session. And then number 2, if we're ready to start talking about another phase of the Opega investigation. And keep in mind, we'll meet on June 15th. That'll be our next meeting where we'll continue this discussion with the department. So I guess I'd open it up to anyone who'd like to offer remarks on where we go from here. Senator Bailey.
So I'll start with the easy one.
Yeah.
Which I think, the indication was if we requested an SDM demonstration, for lack of a better term, that they would be amenable to that. And I would very much like to request that.
Okay. Senator Kime.
Yeah, and just to piggyback on that, I know it was mentioned, sort of the sales pitch approach, which I think would be helpful, but I think the finer details are what we're looking for as far as like, okay, if this, then that sort of thing, so I'd prefer it wasn't generic. And I'm sure that's proprietary, but I think that's really where we're looking to have a view inside of it. And then moving on from that, I wonder about one thing that I would like further information on, prompted by Senator Bailey's question about these reviews, the technical review, and the fact that there isn't much outside view of them, right there. And so there's the ombudsman, but as I was thinking about it, if the ombudsman is, well, first of all, she's paid by the department, right?
Through a contract.
Through a contract, which is questionable. But if you're the only person on a team that's the outsider, it's very difficult to have, I think maybe, I don't know if courage is the right word, but definitely having someone else that's an outsider, I think is something I would like to explore. It's because we really, as a committee, need someone else to be looking in for us. We can't really do it all. And right now, the state is expecting us to offer up some solutions and offer some transparency and a different view inside of the system that is, you know, kind of a black hole because it has to be. So maybe we would want another outside view of someone that answers to us and say, hey, we'd like you, but it has to be an expert in that, right? And we are not that. So my idea of sifting through these reports, or our idea, or that we're considering about sifting through the reports, is good. And I think Senator Bailey, you know, you have a lot of experience with this, but I don't. So I'm not sure how valuable my insight is going to be once I read a report. So that was another idea I just thought of when we were sitting here, is just, you know, is there someone we could get to become a member of that team that does directly answer to us? Just throwing it out for ideas.
It's a good idea. I know the ombudsman does not work for the legislature. It's a contract with the governor's office, or is it DHHS? Governor's office.
It's the executive branch.
Okay. What I was going to say is the ombudsman in my time here has not been shy about sharing concerns about how the department operates. And so I don't recall reading her commenting on this particular process.
It's fairly new.
It's fair. Well, the old and then the new. I'm not sure if she was part of the old process, but fair point. Okay. Senator, Representative Stover.
I had also suggested that we get an update from the department on the 9 pieces of legislation. Well, one's a study, so 8 pieces of legislation that are in various stages of implementation, because we just finished and passed the budgets, and now they're rolling out, and give us some sort of sense of these various programs that we've approved that are coming closer to being implemented, so we can understand better, because we've talked a lot about them, and now let's see. So if we could get a timetable, and they were agreeable to that. So just want to make a note of that. Thank you.
Okay. So we maybe could add that to the June meeting. Senator Kine?
Circling back to my idea, and I'd written it in my notes, then forgot when I mentioned it. I was wondering if the staff could actually reach out to collaborative safety and to the ombudsman. And so with collaborative safety, it's their system that they've developed. And I guess just ask them if we could, the idea of having another person added to this team that's not in-house, and see if they do that in other states, or, you know, what their response would be to that idea. I'm sure it's not a new idea. And, but that might be helpful to us. And then I guess asking the ombudsman as well, that same question, just, you know, if, and I understand it's a new system, so collaborative safety might have more information around that idea than the ombudsman would, but still hearing from her and her idea of asking one more person to be part of that, that answers to us, just her response to that would be helpful.
Okay. So you're asking for a member of the staff at Opega to make those 2 inquiries. Okay. Scott, Matt, is that? I'm seeing a head nod, so we're good. Okay. All right, so we've got the suggestion to have a presentation of the SDM tool, and then a request to view the full review reports. There are 5 available. Do we want to agree to the first one, the presentation of the SDM tool, and table the second one until we've thought through it a bit more? Senator Bailey, thank you. Team effort.
Whichever way you look, the hand is going to be up in the
Yeah, yeah.
opposite direction. That's a good. I would like to have Senator Kine's question answered in terms of how many technical reviews there are before I have an opinion as to whether we should request those or not, because if they're a manageable number, I would like to request them. If we're talking, 500, that might not be helpful. I definitely want the full case reviews.
Okay.
But I can't decide on the technical ones because I I don't, Bobby didn't even have like a guesstimate of what we're talking about.
Senator Kime?
So, and then following up on that, since they're new in February, we don't really have anything to compare them to over a long term. So I'm wondering if we're going to look at anything, do we need to be looking at a longer time frame? But it won't be an equal comparison. I don't know who can answer that question, but that's what pops to my mind when I think about looking at something only recently.
Matt?
So a few things sort of came to mind and I sense sort of a hesitancy to make the request in not knowing exactly what we'd be requesting or seeing. So I think there is some legwork that we as an office can do for you in advance of that June meeting. Universe of the technical reviews, the full reviews, going back in time, perhaps clarifying that table that Representative Arata references, is it 5 for deaths? If they involved a substance abuse, substance use, mental health treatment referral, those things, what is included in the case file, because that's sort of ambiguous and sitting out there also. I think these are all things that we could probably provide and give you a little more context to make some decisions.
Yeah.
If that's helpful.
I think that is helpful. Senator Kime?
Yeah, and in that, I'm thinking, like a 3-year time span would be helpful, but when you look at those, would you also compare what the case review file that maybe is like this memorandum that you came and looked at? I mean, can you tell us how different they are so that when we're looking at one versus the older style, are we going to be able to understand the changes?
And I did sneak over there to look at what Senator Kime had held up. That was a memo from the commissioner following the conclusion of the criminal proceeding related to Marissa. What we are talking about is something internal to OCFS that happens very close to the timing of the incident. So what I would call it a briefing memo, many of which were in the past generated from that CDSI, the Child Death Serious Injury Review tool. And it has evolved, the use of that tool to where we're at now with the collaborative safety model. So I think we can capture all of those and let you know how many have been done, what you're looking at for documentation. I noticed that was like 12 or 13 pages long. We have seen the CDSI, the memo that accompanied the 2 earlier deaths. I think it was 5 or 6 pages. So they're certainly different in what's there. And we might be able to explain better what those things include. And that might be a good starting point for you guys as you figure out what you want to do.
Yep.
Oh.
No, just kidding. I was gonna say into the mic, but just kidding. All right, that was helpful, Matt. Let me try to summarize. We're gonna meet on June 15th. We're gonna continue our second half of these questions with OCFS. We're gonna receive a memo from the OPEGA staff detailing some of the information that Matt just laid out. We can also have the chairs write a letter to the department requesting the SDM tool presentation in executive session and have that for June 15th. I think that would be plenty for the next step. Okay, so let me see, head nods on that. Okay. Okay, so that's what we will do. Do we need a vote from the committee to authorize the chair sending a letter? I can't remember. Okay. Kime, do you have a motion?
like to make a motion that the chairs send a letter to request us to be given a review of the SDM tool.
Thank you. Second. By Representative Fay. All in favor? It's unanimous. Okay. Good. So last piece of our agenda is interim director's reports. I'll turn it over to the staff.
Really, all I had on here was.
Your mic, please, Scott.
Thank you. Not used to that. Mostly was scheduling the next meeting. I can give you a little update on our projects and process. We're currently working on preliminary research on the CPS permanency reunification. We're doing the preliminary research because we did not know a lot about this aspect of child protective services. It had not been part of our previous reviews. So we're trying to use that to narrow the scope of that project. Anything you'd like to add to that, Matt?
No, we may have to make an adjustment to the timeframe or scope but we should be on track to report something back to you if you're having a July meeting. It would land in there. Great. Be able to.
And the staff are continuing on the work plan we adopted last year. They're beginning phase 3. And we may decide on a phase 4, but that's TBD, to be determined.
I also wanted to bring your attention to behind tab 3. I had updated basically the chart on legislation that Lucia had provided last time. So all the bills have been processed at this point. So this gives you the final disposition of them.
In terms of planning for the next meeting, I think we would like to have MCILS provide an update, and I'm going to let Senator Khan. Did we say June or July for that, or maybe staff remember what we talked about?
I think it was July because we've just made changes and we thought they would have a better handle on what that would look like for us.
Thank you for that.
A
So
letter, right? I think we were asking for a letter.
I think we would, and maybe the staff, right?
Yeah, we talked about asking for a letter for the June meeting, just a brief update on where they are, and then have him come back later after they've had time to implement some of the changes brought on by new legislation. Yeah, so we're still on, we'll get him to, we'll make that request. Great. The one other thing, our tax team is currently working on the parameters for a couple tax reviews. As you know, we're statutorily obligated to move on some tax reviews. Getting the parameter set is a 2 GOC meeting process. There's a public meeting and then there is a work session at the next meeting to set those parameters. And we're trying to figure out when would be appropriate to do that.
I think we can be flexible. Let us know what works for you.
Okay, we can, all right.
We do plan to meet in June and July. I think we're all agreed.
Okay,
on
well, they were kind of hopeful they could do the public hearing in June.
Yep.
Okay, well, we'll get that underway as well. Thank you. And that's
Senator Khan.
So can I just clarify the June idea here? So we just talked about finishing the rest of these questions in June, and then the information we've asked for we'll receive as well. But we are also, that's a combination meeting,
No, thank you for asking the question.
right? So, and we were going to have a public comment period as well. So that's a really long day.
Yeah. So what we've learned since Chairs and Lead spoke last is we thought HHS committee and GOC would meet jointly, and HHS would like to go in a different direction, and which is fine. And so they are going to hold a meeting on June 8th with a public comment period on June 8th, which is 1 week before we meet. So we learned that a couple of days ago. So I think we'll have a full meeting if we do the second half of the questions, the SDM tool presentation, and review the material that OPEGA staff are going to collect for us. And so we can hold a public comment period at any point. I'm wondering how us adding a public comment period to June 15th may help or not help us in our work, given that one is going to be happening a week before.
Right, so you're thinking we're just gonna like watch it or something to get that same information?
Yeah, it's challenging to try to figure out how to not waste time and not waste other people's time and not duplicate. And yeah, so maybe Representative Stover.
As a member of HHS, they have a regular, their regular meeting scheduled, and they have LD 1853 passed that has them sort of responsible for a quarterly review with OCFS from now until the end of the 1/30th. So that June 8th meeting is the HHS meeting to begin that quarterly review process. And I mean, it is a public meeting, it's just not a joint meeting. So that GOC members, if they were interested, could come or tune in, but it's not a joint meeting. The decision was made that they'll conduct their quarterly meetings and we'll continue our investigation and research and evaluation work, if that makes any more sense.
I think we can definitely have further conversation in between now and the next meeting. And if we'd like to make adjustments, we certainly can entertain that. We hope committee members feel welcome in making those recommendations and suggestions.
Decide on the tax expenditures today or?
Yeah, I think they're going to plan for
Okay,
next
great.
week. Okay. Anything else? Okay. Any other business committee members like to bring up? Seeing none. Representative Blyer, our motion to adjourn. Okay, second by Representative Arata. All in favor? It's unanimous. Unanimous.
Whatever.